Alrighty.
So
All right. After entertaining a little 20 minutes, we will call to order the August 17th meeting of the Law Revision Commission.
yeah, and before we start, just a reminder to the commissioners and myself and speakers, please ensure that you turn your mic on and speak directly into the microphone so that everyone can hear you. Also, for our commissioners who are appearing remotely, a reminder that the government code requires remote participants to visibly appear on the camera. And then finally, we are moving item 5, formally item 5, antitrust law, to the end of the agenda, and we'll take it up after lunch. So with that, I can
Okay,
call the roll.
yeah, call the roll to establish a quorum.
Yes, Commissioner B,
Here.
Commissioner Carrillo,
Present.
Commissioner Kubas is absent. Senator Gomez Reyes is also absent. Commissioner Hebner.
Here.
Oh, sorry. Is that better?
Here.
Did I call Commissioner Hebner? I'm sorry.
Yes.
Okay. Commissioner Jenkins.
Here.
Assemblymember Pacheco is not able to attend. Commissioner King.
Here.
And Commissioner Simpson.
Here.
I think I have everyone.
Quorum is present. We are now going to go into closed session for a short while. So if the public and others can, oh, there we go. Let there be light. Excuse themselves just for a few minutes, and we'll come back and get you when the closed session is completed. Right. Next item on the agenda is the approval of the minutes from May.
Okay, and I believe Commissioner King is on.
Yeah, I have a message on my screen saying I cannot start my video because it's been disabled by the host. Oh, there we go. Okay.
Look, oh, there
There
you
you
are.
go.
Great. Okay, yes.
Welcome back. Welcome back.
I move to adopt the minutes.
Okay, it's been moved to adopt the minutes.
Second.
And seconded.
Okay.
There's no any public comment? Seeing none, call the roll.
Okay, B,
Aye.
Carrillo,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
Simpson.
Aye. All right. Administrative matters.
Administrative matters. Let me turn my page here.
Mhm.
I'll be brief on the report of the executive director. The budget, our budget remains in good shape, and we're always want to thank Kara Jenkins for helping her staff helping us make sure we're on track with our budget and accounting. And I'll just go to the lease. We are in the process of moving. Many thanks to the staff who, especially Christy and Megan, who put countless hours into figuring this all out and coordinating with the building. And thank you to Kara Jenkins again, because we're getting our furniture from Legislative Council because they had a remodel. So it's been really, really nice, and it's easy because it's within the same building. So in the meantime, we had to work on the lease. Unfortunately, the timing of signing the lease was in between meetings, and we needed to get it signed in order to meet the target date, move-in date of September 1st. So we talked to the chair, who gave us interim authorization to enter the lease, which we did. And so now what we'd like to do is formalize the lease with a vote of the commission.
Is there a motion to approve the lease?
So moved.
Been moved
Second.
and seconded.
Any public
Any
comment?
public comment or questions? Seeing none? We can call the roll.
Okay. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye. And commissioner suggestions. Are there any suggestions, proposals from members of the commission for issues for the commission to consider? Seeing none? Okay. Legislative program.
Sure, that's me again. So I'm pleased to inform the commission that our our biennial resolution of authority was approved by the legislature and has been chaptered. It was received no votes, and so we're in good shape there. And as you see on the agenda, we have added 2 agenda items that we didn't previously have authority to study: the education related item and the item related to writs. Our Equal Rights Amendment study bill is now on the Senate floor. So it's been moving along very nicely. We did recently learn, as you can see in the supplement, it is explained that another bill is amending a couple of the same code sections as the Equal Rights Amendment or the commission backed bill. It would include perimenopause, menopause, or postmenopause, or medical conditions related to menopause, etc. And so in order to avoid chaptering out problems, the author's office has informed us that they'll be taking amendments to make sure that if both bills pass, the language of both bills stays intact.
Mhm.
And if you have any more questions about that, you can ask Rick, because he said that
Or care.
many times at the legislature. Okay, then moving on to the AB 1776, which is based on the commission's recommendation on single firm conduct. As you can see in the memo, it has been amended several times throughout the process. Some of the amendments were included in the last legislative program memo. So, and I failed to mention on Equal Rights Amendment, but the same applies for antitrust, is that the staff is recommending that at this point, the commission not consider making any conforming changes to its recommendation until the end of the legislative session, at which point we can do deeper analysis for the commission's consideration. Things are still in a state of flux. The AB 1776 has turned out to be a pretty high profile bill that's moving its way through the process with several amendments. I'm just going to highlight a couple of them for you. I turn my page. There's if you look on page 5, the commission had originally recommended that the basic language refer to restraint of trade, etc. The amendments that are outlined on page 5 and 6 basically align the AB 1776 closer to federal law. There's been a lot of commentary and questions about whether departures from federal law could lead to confusion and interpretation issues. So I believe that's what's underlying that. Let's see. At the bottom of page 6, there's somewhat of a, well, it's actually a corollary to previous section 16732J, related to relevant market power. I think at the recommendation of the Senate Judiciary Committee chair, the word substantial was added there. at the bottom of page 7, you'll see amendments to, or it's a new section 16731F, and it relates to exclusive franchise contracts, license, etc. And the goal of this amendment, as I understand it, is to have the same sort of exception for these kind of contracts in California law that exists in federal law. It relates to state action immunity, which was a fun doctrine to research. An example of folks who might have this kind of contract is waste companies that cities or counties are contracting with to provide needed services to the county or city. And then the final one that I wanted to bring to your attention, the judicial guidance section 16732 was deleted. Apparently, as it was moving through the legislative process, folks found it confusing. I think there was some suggestion in the Assembly Committee on Judiciary about perhaps how it could be revised to address the confusion. But the one thing I wanted to mention is that it still stands in the bill that the legislation points out that California law is different from federal law, and that as we has previously discussed. And then moving on to the supplement, when we wrote the supplement, AB 1776 was not in print. It is now in print, and I hope you all got to take a look at it. But the supplement accurately described what happened in Senate appropriations. There were technical amendments, and then the bill was amended to limit actions to public prosecutions. So what that means is that private parties can no longer bring a cause of action under AB 1776 as it's currently written. Are there any questions?
Any questions? Any public comment? Seeing none? Okay, thank you. Anything more on the legislative program?
No, that's it.
Okay. Item 5, terminology related to persons with disabilities. That's Sarah?
Yes, thank you. I'm presenting memorandum 2026-30 related to persons with disabilities. And
Can
before
you
I get,
speak up
a
a
little-
lead
Oh.
into the microphone a little?
is this better? Hello, does that
Okay.
work? Okay, great. Before I start in on the memo, I'd like to update the commission on the Assembly Concurrent Resolution 206 that I mentioned last meeting by Assembly Member Stefani relating to Elder and Dependent Adult Abuse Awareness Month. This resolution was passed by the legislature on July 6th. And the reason I'm highlighting it is because it states in part, whereas the term dependent adult is an antiquated pejorative that does not reflect the independence and value that adults with disabilities possess, usage of the term should be avoided and replaced with the term, quote, adults with disabilities to reflect this fact. This is in the resolution that was passed. The resolution also references our study, and that's likely because the resolution was sponsored by the Commission on Aging, who worked with the ARC, who was the sponsor of AB 1906. So this has gone through and was adopted by the legislature. Back to Memorandum 2026-30. It provides stakeholder feedback on the proposal to replace dependent adult or person with adult or person with a disability. And since the last meeting, I reached out to the groups listed in the prior memorandum and requested by commissioners, and ultimately received comments from 7 groups who provided substantive feedback. Of those 7, 4 agreed with Texcom's analysis about keeping some of the terms unchanged. One group was unclear. I asked follow-up questions, but I didn't get anything back. And 2 supported the proposed change to adults and persons with a disability. And regarding Texcom's analysis, I do think it's entirely reasonable for stakeholders to be worried about the effects of changing terms, and particularly to another term that already exists. But having said that, the groups opposed to changing the terms were not just opposed to the proposed replacement terms, although they didn't recommend an alternative, they just didn't really want change at all. Texcom argued that the terms in the Probate Code and the Elder Abuse and Dependent Adult Civil Protection Act should not be changed because their definitions they felt were particularly unique. As you can see from the analysis of these terms compared to other uses of dependent adult or dependent person, I don't really see that they are. Again, the legislature just passed the resolution about the Elder and Dependent Adult Civil Protection Act with no votes, which stated that the term dependent adult should be replaced with the term adults with disabilities. To recap, the legislature did ask the commission to recommend a term to replace the phrases adult, a dependent adult, and dependent person throughout the codes with new terms describing those persons in a more respectful way. And the directive further requested that these changes be made in a consistent and comprehensive manner that does not substantively change existing law. And the staff has suggested to add in uncodified law and in commission comments that the term changes are not meant to change the underlying meaning or application of those terms. But frankly, short of not changing any terms, I think that's the best that can be done to mitigate any confusion. Does the commission have any questions?
Are there questions or comments from commissioners? Yeah, Commissioner Carrillo.
I just had one sort of clarifying question. My understanding is that the legislature has directed us to find a textual terminology solution to the problem that the legislature has identified. So given that direction from the legislature, doing nothing is not an option for us. Is that fair to say?
I would say so. I mean, certainly they ask us to recommend something, and if you found that there was
Nothing.
nothing, then certainly
We
could
looked
say
and we
so.
couldn't
But
find anything.
yeah,
Yeah. Okay. I was focused on some of the comments that preferred the status quo, and I was wondering, like, can we do nothing? And it seems like that's maybe not the best idea.
I would leave that to the commission. I mean, the options are to do nothing, to do exactly what was requested, and or do a hybrid of change some and not change the others. But
Yeah.
the directive was to do it all. So
I'm curious what my colleagues think. I mean, I don't love using the virgule, the slash between adult or person. I would pick one or the other.
oh, to clarify, so we say adult or person because throughout the code, there's defined terms as dependent adult or dependent person. So in those cases where it's dependent adult, that would be adult with a disability. And then where it's dependent person, it would be person with a disability. So there's no slash. It's just for shorthand and
Got it. Thank you for that clarification. That resolves that issue. I'm curious what my colleagues think. I'm fine with going in that direction. That seems like a reasonable solution to me.
I had
Commissioner
a
Jenkins?
question. Thank you. Just to the point where in the memo from, what is it, Texcom, the difference between a dependent, well, being a dependent adult doesn't necessarily mean that they have a disability, right? And that's where I think there could be some confusion. And I wonder if there is a way to separate a dependent person versus a person with disability.
I think that's where things really come down to the underlying definition of what constitutes the dependent adult or person. I think the term disability is really evolving, and that term person with a disability itself has multiple definitions throughout the code. So what we would be doing is retaining the underlying definition. And in my mind, a person who is dependent on someone has some personal need that could manifest itself as not being able and being disabled to be able to do that themselves. Some of the categories of disability are broad enough to include disabilities due to age or due to temporary circumstances. So I think it's fairly broad, but every individual interest group seems to have their a very particular definition within which they currently work, which makes sense, but we would not be changing the underlying definition. It would be the terminology itself. So there'd just be kind of a general confusion of what it means in people's vernacular, I suppose, that they would have to be reapplying in the legal circumstance.
So the enforcement of or interpretation of the definition you're saying would be the same. It's just called something else is kind of what you're
Exactly.
saying. But
Yeah.
it still seems a little odd to me that someone who might be dependent and not have a disability would be called someone with a disability.
I guess in my mind, I think if someone's dependent, they probably have some need. I mean, they're dependent for some reason, and that could manifest itself under one of the existing definitions of disability.
So in your mind, in your review, you don't think that there's a case to keep them separate?
Not really. If I found in the existing definitions very, very different circumstances, but the ones that they pulled out are not exclusive to the probate code or the act. So it's hard to argue that they're very, very different when there's sort of leaky other code sections that mean substantially the same things.
Is the concern that you can be a dependent person, that you're subject to a dependency, but you're not disabled?
Yeah.
So they're not.
And like people who are subject to like elder abuse or, you know,
Right.
they might not have a disability. They're
Right. It's like being a conservatee.
I think that a lot of that goes back to the underlying definition of what that dependency is. So the dependent person would be defined as a dependent under certain terms, and we'd just be swapping that part out, but the underlying definition would remain the same.
I think I go back to when we were doing the fish and game code changes, that we got a lot of pushback from the stakeholders that is so ingrained with the way they enforce the statutes. I wondered if there was something similar here where,
I think that's probably, yes.
and in that case, we decided not to pursue a lot of the changes.
It does seem like there's a substantive, non-technical difference between a person with a disability and a person who's subject to a dependency. Like they're not the same thing. And we would be wrongly conflating the two by using one term to describe both of those categories. That somewhat overlap, but not entirely.
I would urge you, I should have appended it to this one as well, but that put together a chart of the existing definitions of a person, of the various definitions of dependent person, independent adult, and person with a disability. And they were very, very similar. And to make it more confusing, in multiple definitions of dependent person, it says whether or not they live independently, and a person with a disability may not be dependent.
Works both ways.
It's really squishy.
I think that just adds to Kara's concern.
And
Yes.
I agree. And I think that was part of the problem going into this study, that there's so many definitions, and within the stakeholder group, no one really settled on an ideal other term. Persons with disabilities was the leading argument, but because the term is defined so variously throughout, it's really, no one was able to come up with anything different to capture the wide variety of characteristics that circumstances.
Maria.
Is it possible to report back on findings and then get direction from the legislature? I don't know if that was the hybrid model you're talking about, but it seems like our directive was to come up with terms that accurately fit people and are dignified and not demeaning in any way. And that if we use person with a disability for someone who does not actually have a disability, that could be problematic.
Kind of makes it worse.
Agreed.
Can we
I
just,
certainly think that's, if the commission would like me to prepare something like that, that's,
Mr. Chair?
Yeah.
So I certainly agree with my colleague Commissioner B's idea of going back to the legislature and, sort of reporting progress and requesting further direction. But circling back to the legislature's original directive, and one way to read this is all they're asking us to do is come up with a different non-pejorative term to replace dependent. So can we just make something up?
and also.
Make up a novel term and swap it in for dependent?
The stakeholder group did look into
Yeah.
that as well. And to bring us back to the very beginning of the study, the original bill requested that the terms disabled adult and person be replaced with person with a disability. Within the Judiciary Committee, it became a study because the difficulty, you can't just swap them out across the code. There are so many ways, particularly with the phrase when it said and others around the person with a disability, because frequently elder and dependent adults, you have to switch them a couple places, and then in a couple of sections, it intersects with other areas. So my understanding is that they largely sent it back to us because it was not that they were opposed to the phrase persons with a disability. It was because they didn't have the bandwidth to do it halfway through the legislative session themselves.
Okay. So I wouldn't propose just substituting a random word like, rutabaga or squeezle. But
Person with special needs or something like that. It's kind
well, I
of,
was thinking a person in care.
I think I have to go back to all the notes, but I think that's part of there was a definite tension between individuals who lived independently. So being in care, there was also a person with support needs was another phrase that was suggested.
Mhm.
I'll have to go back to the prior memo, but there was a lot of discussion about different combinations of words and phrases. And I think the persons with disabilities came to the fore because at the federal level, they're using it frequently in place of this term. The regional centers are using persons with a disability. And I think, at least in my mind, the term disability has broadened. And in the statutes, it really is, definitions are quite wide. Having said that,
Yeah,
I'm certainly open to other suggestions, and we
Yeah.
can go back to the stakeholders
I
as
mean,
well.
given Karen's concern, I would not go in that direction.
I actually have the opposite view, David.
Victor?
When you look at the difference in the definition of disability between California and federal law says that disability has to substantially limit a major life activity, but California does not have the word substantially. So the threshold in California to have a disability is far lower than in the federal scheme. And I am very comfortable with saying persons with disability.
Yeah, and there are multiple definitions of person with disability in California law as well.
Other comments or questions from commissioners? I mean, I'm just wondering, is there some way to do it like a person with a disability or special need or something like that could be broader?
Special need, like I wouldn't,
Yeah.
it seemed like part of the problem we're having here is using person with a disability, like that imports, it's a little bit like our antitrust study. Like we don't want to import existing definitions
Right,
of things. So that's why I was reaching for, like, I think in care is actually a British term. And to my knowledge, it's not something that we use in American law. So it doesn't have an existing definition. It's sort of on a kind of common sense level. It sounds like the concept that we're reaching for here, but it doesn't have an established definition. So something like that doesn't bring with it all that definitional baggage, but sort of captures the concept. Like I think that's what we need here. In addition to asking for further direction from the legislature.
Yeah.
But it definitely seems like I can easily envision somebody who's subject to a dependency, but has no disabilities. And if the
Right.
whole point here from the legislature is to be more respectful, that makes it worse. telling somebody you are disabled when they're not.
Mhm.
That's,
Would you like me,
we're not doing our jobs if we go that direction.
would you like us to reconvene the stakeholder group? The main sponsor, I mean, a lot of the stakeholders themselves were okay with persons with a disability, but other people
Kinda
had
amazing.
different words as well, so.
Yeah, I still go back to the difference in definition between California and federal law. In California, it's any limitation, a physical or mental condition that creates any limitation on a major life activity, not a substantial limitation. I think that's broad enough to cover everybody. And so again, I'm very comfortable with the legal definition of people with disabilities. I think we're sort of biased in thinking that a layman's term of person with disabilities is pejorative. But I think legally speaking, a person with disabilities is a hugely wide category in California.
Okay. Um, so what,
Is there anyone, we could ask for public comment too, to see if
okay,
anyone
yeah,
has.
a good idea. Is there any public comment? Not now, okay. I just had one, not on what the definition is, but in the uncodified statute, rather than saying this is not meant, whatever we end up, if we end up recommending something, it's not meant to change the underlying definition. I would be stronger. I would say shall not be found to, something like that. I mean, a court could say, well, you didn't mean to, but you did. And I'd rather have something a little more firm, saying, it shall not be found to, something like that. So,
So I would like further clarification from Commissioner Jenkins and what you're thinking. Are you thinking that it's something we really can't do, or there's some solution, or we do part, or?
I'm not sure. I guess the stakeholders, I'd be interested to find out more from the stakeholders, for instance, the folks from the DOJ who, express their concerns, especially, I guess there's some judicial council forms that would need to be changed. And just in terms of like what this means for administratively, I don't know if we
Sure,
can do that.
I can speak a little bit to the judicial council forms, is that those forms have to change all the time because laws are constantly changing, and it's not, they have a whole system set up to do that, and it's something that's done on an annual basis, so it's,
But in terms of like
but there could be
interpreting it,
more, yeah,
Yeah.
there could be more.
right. It's just a little unclear to me, like how this might impact enforcement of other statutes.
Okay. So it
I don't
would be
really have a
helpful to have further information on how this impact enforcement of the statutes for
Because
for the folks who have to enforce them.
The comments that we received seem to want to exclude the probate and the welfare and institutions code sections. And I don't know if there is some way to reconcile that, or if it would be too confusing because we're making some changes throughout and then not there. So I think we would want a little bit more information as to the impact of the change, at least for me. I don't.
I'm happy to ask for further clarification. Interestingly, DOJ said that they agreed with the TexCom's analysis, but the example they gave was related to a judicial form that referenced the penal code, which was not part of TexCom's concerns. So I think it's an interesting tension between the individuals who want the terms changed, at least in that's within the individuals who are immediately affected as to their person, as versus the stakeholders who apply the law who don't want it changed. And I think that may be what is one of the essential tensions.
Well, and one of the priorities of the directive was to ensure that the language of California laws appropriately recognize and represent people with disabilities. So could this be narrowed to only people with disabilities and not dependent?
I think that goes,
Adults?
Back to the definition. So, for example, adult with a disability is, for example, an insurance code, it's a person with disabilities is a physical or mental impairment. In Welfare and Institutions Code section, it says any disability, including but not limited to an intellectual or developmental disability, cognitive disability, communication disability, psychiatric disability, physical disability, sensory disability, learning disability, dementia, cognitive impairment, Alzheimer's disease, major neurological disorder, or chronic illness or condition. So someone with cancer could be an adult with a disability, as well as someone who is conserved.
I understand that the definition is different than how people might perceive it or enforce things. So that's why I'm more concerned with how this would, if in practical matters, impact how.
I can
the
ask for
statutes
further
are
comment.
enforced.
Would that be? I
I'm
can ask
sorry.
for further comment from DOJ and Texcom. Is there anything particularly that you feel they didn't address in the comments they submitted?
Well, they didn't provide an alternative, but
Right. I think, yeah, I know
Nobody
that's
did.
what I struggle with too, because I think they don't want any change. So I don't
Right.
know that that's,
that's true.
yeah, so.
Mr. Chair, can I ask kind of a dumb question?
I'll give you a dumb answer.
Yeah. I didn't notice it in the memo, but maybe did the legislature give us any sense of why, this is kind of a first principles question, why the legislature felt that the term dependent is pejorative, like why it's disrespectful to use that? Like, what's the motivation for changing it in the first place?
This was brought by the ARC. It was the original, I believe, sponsor of the study, of the bill that issued the study, and it's representative of individuals who are defined as dependent adults, and those individuals felt that that term was disrespectful because they are not necessarily, many of them live independently, and they felt that it was not appropriate.
Hmm. Okay. I'm just wondering if we can.
And that's how I view that.
Go ahead.
Any term is going to be insulting to somebody. There's
And
just
That's
so,
a lot, what are the
but-
stakeholder groups, everybody was.
But in terms of weighing the differences, I think being called dependent is more insulting than being called disabled. And the reason I say that, I've been Googling while you've all been talking, and there are advocates who say, we have to get over this concept that the word disability is a pejorative. And one of the ways we get over the concept that the word disability, persons with disability is a pejorative, is by using it in a broader context, as not meaning that you're, woefully ill or completely incapacitated. It's sort of a chicken and egg thing. If we push the law to say persons with disability, and it's applied to people in a broad range of things, then that in some way makes the word disabled less a pejorative, where there's no way to make the word dependent less a pejorative in my view.
But by broadening it, do you risk changing the intent of the underlying statute? That's my concern.
Well, but it's already incredibly broad. I think it's safe to say California, the definition of disability is broader than any other state or in the nation. And so if we have the language, and I like Rick's suggestion that we be a little stronger and not just say that it's not meant to change the definition, but Rick makes a very good point to say it shall not change the prior definition. But I think I see this as a positive, that if we start all using the phrase person with disability, that will help the public understand what lawyers understand, which is that virtually anything is a disability. Again, under FEHA in California, any physical or mental condition that limits a major life activity, not substantially limits, but just limits a major life activity. So literally anything can be disability, and by broadening it, it takes the pejorative away, I think. But anchoring it to what Rick said, that we don't want to change any definitions and be firm about that.
Yeah, Maria.
Sarah, so was it clear from the stakeholder meetings that person with disability, using the word disability is not seen in a negative way or a pejorative way?
I would say that was the overall tone. And there was not a clear winner within the stakeholder groups. But I would say that the tone, I think, sounded different from that group. I don't think they automatically thought it was as pejorative as perhaps maybe we do. And I think there's a recognition that at the federal level too, it is expanding, the term disability is broadening generally. So it does encapsulate people who live independently, people who may be dependent, people who can operate sort of transparently, or some people who may need help. So, and I think that a lot of that has to do with the discussion around mental illness as well. So when people have hidden disabilities and things of that nature.
Okay, so I'm not sure where we go from here.
I'm happy to do further outreach to the stakeholders and to sort of the DOJ and
Yeah.
HEXCOM and other folks if
Can we ask them to have a meeting and settle on a term that they can live with? That would be super helpful.
I did ask TexCom if they had a substitute other term and I.
No, I noticed that,
So,
that
yeah.
nobody had any alternatives.
Yeah.
Right.
I mean,
Hmm.
so I'm looking at page 3 of the memo, and the definition in Penal Code Section 368H, dependent adult is defined in much the same way that Victor just read off the definition of person with a disability. So, to a certain extent, these definitions are arbitrary.
Mhm.
I mean,
We can call a
the
person.
Venn
an octagon
diagrams have
and define it.
slivers like this much on either side. So yeah.
Yeah, so,
Yeah.
I don't know.
Chair, could I ask a
Yeah.
question? Sarah, is going back and asking more questions just delaying this, or do you see anything productive that comes out of churning it further?
I certainly don't want to interrupt the commission's deliberative process. Nothing better has jumped out to me so far, personally.
As I understand Commissioner Jenkins' point, sorry, I keep putting you on the spot, but you're interested in maybe more practical consequences, how things are done on a practical level versus just looking at the letter of the law. Is that?
Yes, I think, like for the landlord tenant study that we did, when we went through this whole process, and then at the end, we decided it would be better to recommend no change because doing so would cause confusion. I think we should be open to that and not feel like we need to come up with something and, unless everyone agrees that it's like, yeah, and that's the problem.
Yeah.
I feel like, is there a point where we decide that the recommendation is, there's no good recommendation? I'm not saying that that's what I'm proposing. That we should be open to that and not feel pressure to come up with a term.
If I might add for the landlord tenant study, I think particularly in that case, and I worked closely with Steve on researching the other definitions, I think that was a circumstance where a landlord and tenant, changing that would be so far ahead of what everybody understands landlord and tenant to be. There was nothing that was a second choice or even evolving in that direction. And I think in this circumstance, we're a little bit closer, but clearly not all the way to moving to a different term. So it's the same kind of circumstance. It's just a little bit further ahead, but clearly not all the way there, I think. But this could further it if that's what the commission would like to propose.
Well, I'm not sure where we go from here.
I mean, if you'd like, I could invite individuals from the individuals who are currently defined as dependent, perhaps someone from the ARC or another stakeholder group participant, and perhaps someone from TexCom would like to come. You could hear firsthand about.
Yeah, we could have a.
I have a suggestion. Brett, I'm going to take the ambassador's point about subjecting this to further churn, and I would suggest, and I'm prepared to move, that the commission consider a tentative recommendation to report back to the legislature that we looked at this, found no consensus on an alternative term. And so we would recommend doing nothing and sticking with the existing definition, the existing term, dependent adult, all the existing definitions, nothing changes. Put that as a tentative recommendation and solicit comment on that. That would be my suggestion. So we're actually like moving the ball down the field, but the door is open to further comment. And if somebody comes up with a genius idea, I will grab it.
I second the motion.
I'm sorry, that was a motion?
No, I
am
thought he
making
was
that motion.
making it.
Sounds
If
like
he's
the ambassador
making it, I'm
seconded
seconding it.
A second, okay. Victor, were you gonna?
Yeah, if the motion's been seconded as a discussion point, then I really want to stick to my guns on this one. I think it's perfectly fine to move to the
you
definition
speak
of
up a little
persons with
bit?
disabilities. Excuse me?
Can you speak up a little bit?
Yeah, I want to reiterate what I've been saying. I think it's perfectly fine to move the definition of person with disabilities. I can't be clairvoyant, but I think if you brought people in, there are many people who will say it's very insulting to be called dependent. That's just on its face. That people don't want to be called dependent. I guess it's sort of woven into our nation that, we're a nation of independent people and independent movers and shakers and thinkers. And I think people are insulted by the phrase dependent. As I understand the word disabilities, it's not insulting. It just isn't. Because those of us who work in the disability realm, and I did handle disability claims for most of the CSU campuses, disability can mean anything that limits a major life activity. So eczema in a certain situation could be a disability. Slight anxiety as opposed to paranoia could be a disability. Disability is not a pejorative term. And to the extent that some people believe it's a pejorative term, I'm advocating that we move forward with persons with disabilities because using the phrase disability will help lessen its pejorativeness, whereas dependent will always be insulting, period. But there's a motion, so there needs to be a vote.
Okay. Any other question or comment? Any public comment so far? No. All right, we have a motion in front of us.
Can I ask,
Yeah,
sorry,
Kara.
so you would rather do the motion instead of going back to clarify with the legislature? Or you're saying this motion will serve as clarifying with the legislature?
I think we can do both. We can use this to get clarification from the legislature, to let them know this is what we're thinking about doing. See how interested they are in moving this in a different direction. It's a good way to get stakeholder comment.
This would be, so this is a tentative.
Yeah, obviously tentative, yeah.
Yeah.
So if we get a big brushback from the legislature and they say, no, we're very
What's wrong with
interested
you
in this,
people? Yeah.
this is a big concern, then we'll go a different direction. I think there's an argument that everything that Victor said about a particular term being pejorative or not, you can reverse that and make that same argument apply to dependency, that it is or is not necessarily pejorative. It's all in the eye of the beholder.
Mhm.
So, I would want to know if, like, take the temperature of the stakeholders, like how bad do they feel like dependent is, how important is it to them that we change it to something else, whatever the something else is.
Mhm.
Same with the legislature.
Okay.
And especially what I'm looking for is whether there's a consensus on what the something else is,
Yeah.
because we don't have that so
Yeah.
far.
I'm seeing it. Okay.
Do you know what the process is, Sharon?
I'm sorry.
The process for going back to, I think it was Assemblymember Gibson's original, wasn't he the original? Yeah, and I think he's
yeah,
might be leaving. I don't know what the
I'm-
process is to go back to the legislature.
I don't think there's anything in our handbook that speaks to that, so I would have to research it to figure out what to do. I mean, theoretically, I guess we could do a final recommendation, of this is where we're at. We couldn't come up with a solution, but legislature, can you give us further direction? I don't know. I mean, maybe it's something we could look into more and report back. at the next meeting, we might have to be creative. Maybe there's a creative middle ground to get more.
Yeah, we
Um,
could certainly have maybe informal conversations with the staff, particularly of the committees
Committee
or,
staff, right, yeah.
that the bill went
I
through
wouldn't do a final
originally.
recommendation, I'd do a tentative recommendation.
So the idea is that we would circulate the tentative recommendation as widely as possible with legislative
Yes,
staff
feedback.
and legislative members. And obviously the stakeholder community.
Sure.
And then from there, the commission could think about where you want to go next.
But before we vote, can someone define what the tentative recommendation is? Because I'm a little lost here. Is a tentative recommendation to move forward with the persons with disabilities, or a tentative recommendation is that we can't decide?
I wouldn't phrase it like that. My motion was that we would report back to the legislature that having looked at this, there's no consensus that we can perceive on a different term that would be better. And so we would recommend that the legislature make no change here.
So the recommendation is to stay with the status quo. That's what
Yes.
the motion is.
The recommendation is to do nothing in the
Okay.
absence of any better ideas.
In the absence of better ideas, yeah. All right, well, we have a motion in a second.
And Sarah, I just want to make sure, are you clear on what the motion is? Okay,
I believe so. Mhm.
Okay,
okay.
all right.
Can I ask a question? So is there another vehicle short of a tentative recommendation? Is there another way to get that feedback? Or do we have to say this, or do we have to actually give a recommendation, even if it is tentative? Does that make sense?
Yeah, I think what Sarah is saying is we could do some informal outreach.
Yeah,
with
so I don't,
community staff and stakeholder communities, et
Yes,
cetera.
so if the commission wishes, I don't necessarily have to put together a tentative recommendation that would be posted as a tentative recommendation. We could just have another staff memorandum after having solicited feedback on the proposed tentative recommendation.
Yeah, I would agree with that. I think it's excellent to get more feedback. But if we were to actually issue a tentative recommendation to stay at the status quo, that's much firmer than I think where we're at. And secondly, going back to David's original point, is that we were asked to look into this to make a change. So it's a little jarring to be asked to make a change and then to come back with a tentative recommendation saying we tentatively believe there should be no change. So I'm very much for Sarah getting more input, but not issuing a tentative recommendation.
I think that's where I am too. I'd like to get that feedback without actually coming out and saying we're recommending that there be no change.
Okay, so we could just put this over till this next meeting and ask the staff to do more outreach?
Or you have to take the vote, or someone has to withdraw the motion, right? I mean, it's already
Okay, we have.
seconded.
I think it's staff guidance, right? So we don't necessarily need a vote if we're not going to do a tentative recommendation. Oh, there's already a motion.
Yeah, there's a motion on the table. I mean, unless somebody wants to withdraw their motion or second.
If the consensus is to churn it a little bit more, I'll withdraw. But I think there's value in like putting something on the table and making it real. And
Saying, here's where we are at the moment.
yeah, that'll inspire people to come forward. It's a little disappointing that the process, no disrespect to staff, but it's a little disappointing that the discussions that have happened so far have essentially resulted in no consensus.
Right.
So, so that stymies the staff and what they bring to us, and then that stymies
Right.
us. And, we've been talking about this for half an hour and nobody has any good ideas.
Right.
And in the absence of any good ideas, to me, that's an argument for doing nothing. And yeah, my initial comment was the legislature asked us to look at this. Going back and saying there is no consensus on a new and different
Yeah.
term, I think that's an answer.
It's functionally the same as, I think somebody said, landlord tenant.
Yeah, and I agree with the ambassador. I strongly suspect that if we kick this, we'll come back with much the same. We'll have this same problem at our next meeting.
Right, right.
So I'd rather put people
Okay.
to the proof and say,
All right.
okay, like if there's a better idea, bring it out.
Okay.
Yeah, and
Well, let's-
my second wasn't to be flippant or to try to close it down.
Yeah,
My second is I view the commissioner's suggestion as a good way to focus attention now.
stimulate response.
Right.
Yeah,
Yes.
stimulus response. Okay. Well,
Yeah,
let's-
but issuing a tentative recommendation is always going to be taken as what it says it is, a tentative recommendation. It's not in a solicitation. It's too strong of a vehicle for solicitation.
So I
Okay,
thought
so-
Commissioner Carrillo withdrew the motion, but,
No.
oh, no, okay,
Nope. Okay, let's call the roll.
okay. Commissioner B?
No.
Okay, no. Commissioner Carrillo?
Aye.
Commissioner Hebner?
Aye.
Commissioner Jenkins? Good.
Yeah.
So
You want me to come back to you? Okay. Commissioner King
No,
and Commissioner Simpson.
Aye.
so there's already I'll abstain then. Thank you.
Okay, abstain. So we have 1, 2, 3 ayes and 2 noes. So the ayes have it.
Okay, it just takes a majority of those present and voting.
Yes, I believe so,
All right.
because it's a tentative recommendation. We did make some
To
changes.
be clear, I'm not married to this.
Yeah.
So in the discussion, if somebody comes up with a good idea or there's a consensus that emerges, I will be
This is-
happy to change my position.
This will stimulate
Yes.
more people
Yeah.
involved.
That's my hope.
All right.
Okay,
Okay, how about civil discovery?
Yes,
Amy.
thank you. Good morning, Commissioners. So this is Memorandum 2026-31 on the Civil Discovery Improvement Study. So this memorandum gives some background on the Civil Discovery Act, as well as the bill that made informal discovery conferences law. And then it gives a status update on our outreach efforts to date and some policy questions that are beginning to emerge as a result of those efforts. So first, the Civil Discovery Act was intended to be self-executing and require limited court intervention. But in practice, that really has not happened. Discovery disputes remain one of the most expensive and time-consuming parts of litigation, as I'm sure any litigator will tell you. So in response to that, some courts actually began holding informal discovery conferences as a way to resolve discovery disputes without needing a formal motion and hearing. And AB 383 temporarily codified that practice, but that statute sunset by its own terms in January 2023. So now we're evaluating whether AB 383 was successful in offering a more cost-effective and efficient alternative to discovery motions. So at the last meeting, we explained that we had come up with a survey and the commission weighed in on the questions. We've now circulated that survey to a large group of stakeholders and received a pretty good response, about 160 survey responses to date and counting, from judges and practitioners. So many of the survey respondents also offered to engage with us further in follow-up interviews. And thanks to them, we have conducted numerous follow-up interviews with judges, practitioners, a discovery referee, law professors, and even an economist who actually did an empirical study on the effectiveness of IDCs in Los Angeles County. Los Angeles Superior Court also prepared a report specifically for the commission. And so that is attached as an exhibit to the memorandum. And it just compiles data from its usage of IDCs, both during AB 383 and since its sunset. And that report concludes that IDCs in Los Angeles are effective in reducing motion practice. So thanks to these interviews, there are some policy questions that have emerged that I'll just run through quickly. One issue is whether parties should be required to request an IDC before filing a discovery motion. Under AB 3, it was actually optional, but some stakeholders have thought that maybe it should be a requirement. Another issue is whether tolling of the applicable discovery deadline should be discretionary, as it was under AB 383, or automatic. Another issue is whether courts should be able to take into account what happens at an IDC when deciding whether to award sanctions later on. If, for example, the IDC is not successful and it becomes a motion. And then finally, whether judges should be able to memorialize outcomes at IDCs through some sort of order. So we'll continue to evaluate these issues and identify any others that arise during our continued interviews and review of the survey responses. We're still sending out the survey and still waiting for some responses from some stakeholder groups. And we intend to present our analysis of this feedback and any preliminary recommendations at an upcoming meeting. But with that, does the commission have any questions or comments or any suggestions for additional research that we should look at?
Questions or comments from commissioners? I had one. I couldn't remember. I wasn't sure if it was in the memo, but how did this come before us, and what specifically is our charge?
Yes, so I believe we're supposed to look at the Civil Discovery Act as a whole. But then I believe it was in 2017, there was a commissioner who wanted to look at depositions and just some uncertainty that there was with respect to the Code of Civil Procedure sections on those. The commission decided to put that on hold because it thought that AB 383 might have an effect on that. And so now we're looking at AB 383, whether similar legislation should be enacted, but eventually, because it's such a broad charge of looking at the act as a whole, we may go back to the deposition, or many stakeholders have gripes about things in the Civil Discovery Act, so lots to look at.
And earlier this year, the commission actually approved the staff moving forward, or
Okay.
going back to this now that AB 383 is off the books.
Okay. And basically, like, they asking for our insight as to whether we ought to reinstate 383, and if so, changes to make, that sort of thing.
Exactly,
Okay,
that's right.
good, thank you. Any other question or comment from members? Yeah, Maria.
So I assume that when you go back and do additional research and survey other stakeholders, if the first thing you said, one of the things you're looking at is whether the IDC should be mandatory, and I'm just wondering what impact that would have on court resources. Seems like that would be a lot of IDCs. So
Yes, that's true. And that's an idea. It could be mandatory just for the litigants to request an IDC, but it could still be within the court's discretion whether to hold it. So that's one possible solution to that.
okay, thanks.
And we have been reaching out to the Judicial Council. So before we did something like that, I think we would want to see where the Judicial Council would be on it.
Okay. Any other question or comment from members? Any public comment? Nope. Okay. Thank you. Our next matter is writ large. So, sorry.
Yes. So this is Memorandum 2026-32. And so the legislature passed Assembly Concurrent Resolution 168 at the end of July. And thanks to that, the commission now has authority to study whether the Code of Civil Procedure should be revised, specifically as it relates to whether the provisions governing writ procedure should be revised. So Commissioner Carrillo submitted this topic on behalf of Justice Bromberg of the 6th District Court of Appeal. And Justice Bromberg thought that this topic was appropriate for study because California's writ practice is confusing, inefficient, and inconsistently applied. And so since the legislature passed ACR 168, we have begun conducting preliminary research and contacting some stakeholders. We actually met with Justice Bromberg to discuss directions for future research. And we've been working with the California State Library to research the history and development of the applicable Code of Civil Procedure sections. And we thank them. They've been incredibly helpful. We've also interviewed some practitioners, and those practitioners have echoed Justice Bromberg's concerns so far. They've also made a couple of suggestions. One suggestion was to modernize the terminology in the statutes to make it easier to understand. and also streamline the process and make it less costly to try to increase the access to justice and those that actually can file these writs. So we recommend that we continue to do this preliminary research and continued outreach to the stakeholders we listed in the memo, including judges, justices, writ attorneys who actually work for the appellate courts, and associations whose members may have feedback on writ practice. And once we've completed this, we can return to the commission with recommendations for the appropriate scope of the study and a research plan. So with that, does the commission agree with this approach or have any suggestions for additional outreach or directions for the study?
I do have a suggestion.
Yeah.
Based on how we handled the mediation confidentiality work, if you remember, those who were on the commission back then, Barbara Gale, our research attorney back then, did a 50-state survey. And I'm not saying we should do a 50-state survey, but it seems to me that we should look to comparably large states like Illinois, New York, and whatnot to see how writ action is done there. Because I agree with Justice Bromberg that the way we handle writs in California is very antiquated and confusing. So I didn't hear in your discussion of input actually looking at certain other states to see how writ practice is handled in other states.
Great. Thank you for the suggestion. We'll definitely look at that. And also other jurisdictions, we intend to look at the federal model as well.
But not 50 states. We don't have to do what Barbara did on mediation confidentiality.
Thank you.
Okay. Other comments or thoughts? Commissioner Carrillo, look okay to you?
We're fixing that.
Oops. It's a.
That looks great. Thank you.
Consigliere, yes. Okay. Okay, any public comment? Nope, none? So I think your proposed, how to move forward makes sense and makes sense to everybody else. So thank you.
Thank you.
Okay, and education reporting.
So I'll be presenting memorandum 2026-33 related to education reporting.
Sarah, can you please lean
those
into
both
the
are-
microphone a bit? Thanks.
And I will be working on this study with Sharon. So in addition to the individuals and groups listed in the memorandum, we plan to reach out to school employee organizations like the California Teachers Association, the California School Employees Association, and SEIU to get their perspective, as well as the California Charter Schools Association.
You might also include the California Federation of Teachers,
Ah.
the smaller of the two unions.
Sharon and I also spoke with the California School Boards Association, who originated the study with us, who suggested additional contacts individuals to get further background on the issue. And as noted in the memorandum, I did reach out to the California Department of Education, and they did follow up with additional information, unfortunately, none of which identifies reports to delete or consolidate. However, based on our conversations to date, it does appear that about 85% of the universe of LEA state reports have been identified.
Okay.
Our next steps will be to unearth those other 15% and work with stakeholders to determine how best to analyze them for necessity and duplication. The good news is that stakeholders seem very excited about this study, and there are many groups and individuals willing to help. Does the commission have any questions?
Any questions or comments from commissioners?
I see that in the memo you don't list the Los Angeles County Office of Education. That would be an obviously large one that we would probably want to add, assuming you haven't already done it.
Do you say the LA County office or the LA Unified?
No, LA County Office of Education.
Okay.
Yes, we did get an individual from LA, I'm not sure whether it was county or unified, to speak to from the board. They were very involved in this before too. So.
Yeah, I'd be a little careful about LA Unified and Sacramento City. Some of the districts that have serious budget problems may have a different incentive for doing more reports or fewer reports.
Interestingly, from another perspective, they said that folks with significant existing budgets may not be as bothered as with the multiple reports because they have existing staff who kind of do them regardless of the apparent need.
Yeah, my comment was on the county office education.
Yeah, county
I
office.
wasn't focused on the individual district.
Okay.
I will definitely reach out.
Any public comment? Nope, no public comment. All right. Look forward to hearing more about the reports, and with that, the hour of 12 o'clock having arrived.
I move lunch.
Lunch, okay.
How long do you want to go for?
45 minutes? 45 minutes? That work? 45 minutes? Okay. We shall stand. There we go. All right, are we
Mhm.
ready to go live? Yes, okay. The hour of 12:45 having arrived, the Law Revision Commission is reconvening. Commissioner Jenkins won't be with us this afternoon. She has legislative responsibilities over at the Capitol. But we will be spending this afternoon on item 9, antitrust law. And Sharon, you want to start us off?
Sure. So this memorandum 2629 is largely based on the memorandum that was presented at the May 22nd, 2026 meeting. It also includes feedback from that meeting by the commissioners who were present at the meeting. At that meeting, there was general agreement among the commissioners present that the mergers and acquisition recommendation should include the basic framework and purpose draft language that is included in the memo. There were mixed opinions about including draft language drawn from the 2020-23 federal merger guidelines that include the HHI. And there were also mixed opinions about clarifying the phrase maybe to substantially lessen competition. A couple of commissioners indicated that they would like time to further digest the prior memorandum before deciding on language for a draft recommendation, but the staff has not requested to do any additional analysis. And then several commissioners also expressed that they would like to hear from the commissioners who were not able to join the last meeting before making further decisions. So then going back to the March 2026 meeting, at that meeting, the commission requested the staff to research the philosophy behind and explore possible variations of the standard for evaluating the lawfulness of a merger. And relates to the language that states maybe substantially to lessen competition from Section 7 of the Federal Clayton Act. The commissioners also asked for clarification on the federal standard, particularly the term may be, to include the citation for Philadelphia National Bank in proposed language, to include the single firm conduct purpose statement as a separate section, and note that the federal merger guidelines should be considered as persuasive authority. So, as I think everybody knows, the original Clayton Act was passed in 1914, and there were a few amendments along the way relating to the phrase may. I think at was originally maybe to substantially lessen competition. It was amended in the 50s due to frustration over the extent to which the American economy had become concentrated and centralized in the hands of a few corporations. And then the Clayton Act was amended to apparently correct a split infinitive. I'm looking at Cheryl. She explained this to me.
I just want to
to-
know for the record, I'm fine
Sure.
with that. Splitting the infinitive. I'm fine with it.
Well, I will tell you, it has always struck me that those two ways of phrasing that are substantively different. That substantially is a magnitude. The first phrase is maybe, that's a probability. What's the likelihood? Lessen competition, and lessen competition is the outcome. And it seems, it always, when I was reading it, it always struck me that the way it first was, which is maybe to substantially lessen competition, it applies as substantially to the outcome. The magnitude of which competition is lessened. The other way they change it to would maybe substantially to lessen competition, applied this substantially to the probability. That's
So,
My-
so I asked Cheryl
If you're, I have
Prepared.
derailed the conversation.
for this conversation, and I think she can add some insight.
Well, I don't know if I can add insight because I'm not a grammarian. I'm with Rick that it sounds different, but I think it substantially does go to the quantum of harm and is in both formulations. It's really just a question of where they put substantially. So maybe to substantially lessen competition. You still have that quantum element when you rephrase it to maybe substantially to lessen competition.
Well, see, I'm not sure I agree with that. It'd be that sounds to me like it's applying the quantitative to the probability, to the may. Maybe
I'm,
likely to substantially, so anyway.
but the maybe clearly is the signal for the
likelihood.
incipiency standard, that it goes to probability.
Right,
Or the certainty of the anti-competitive effects.
right. Okay, sorry to get into the weeds.
Okay, so in our quest to add further clarification, Sarah did a great job researching the history of the Clayton Act and found in a Senate report on the 1950 amendments that the may, as used in the bill, would not apply to the mere possibility, but only to the reasonable probability of the prescribed effect. So as I get further into the memo, that was an important discovery. So as we read it, Congress understood maybe only required evidence of a reasonable probability that the acquisition would substantially lessen competition or to tend to create a monopoly. And so that was understood at the time and reflected in a U.S. Supreme Court decision, Brown 2, which I think we've discussed before, that maybe does not require certainty about future harm from a merger.
Right.
It does require some likelihood. And it again used, and subsequent case law again used that term reasonable probability. Meanwhile, in 1963, the U.S. Supreme Court decided Philadelphia National Bank and recognized that mergers occurring in highly concentrated markets were inherently likely to have anti-competitive effects and were therefore illegal. And in the court's analysis, they recognized the difficulty in proving anti-competitive effects in these markets and expressed concerns about plaintiffs getting mired in the or in the effort to produce evidence. So in that case, to reduce the plaintiff's evidence burden, the court created a structural presumption that presumed illegality if plaintiffs could demonstrate that the resulting merger would probably result in a highly concentrated industry. And so once the plaintiff is able to make that showing, then the burden of proof switch to the defendants to clearly show the merger is not likely to have such anti-competitive effects. Notwithstanding Philadelphia National Bank, the trend has been to weaken that over the years. We've talked about the Chicago School previously, who were arguing for a narrowly tailored enforcement standard focus on economic metrics such as price, output, and efficiency. So as a result, the criteria was narrowed for evaluating mergers and increased the burden on plaintiffs to provide more certain evidence of anti-competitive effects, despite Philadelphia National Bank remaining good law. So the courts were interpreting it to show probable anti-competitive effects with greater certainty than a reasonable probability, notwithstanding the legislative history of the amendments to the Clayton Act, and looking at things like, is it likely, would it be likely, will probably, or even would result in the harm. Then in 2023, the U.S. Department of Justice and the Federal Trade Commission released updated merger guidelines, which are reflected in the memo, which seem to, go back to more of the Philadelphia National Bank philosophy. However, while they appear to signal a reset of federal enforcement priorities towards protecting competition and away from market efficiency, the shift has not necessarily been reflected in actual enforcement activities. So at this point, I'd like to ask if any of the commissioners have questions. Cheryl is very prepared to answer anything you may have.
Questions from commissioners? So, just so I understand, the back and forth was about the likelihood, and how likely does it need to be that this merger is going to harm competition?
Yes.
And it also at some point moved away from competition being the primary goal, public policy goal, and moved to price and efficiency and whatever some of those other those kinds of sort of consumer, is that the consumer welfare kind of benefit?
Well, I think you're talking about the effect of kind of the Chicago School influence on antitrust, which emphasized market efficiencies. And they didn't care whether the benefit of those efficiencies went solely to the shareholders or whether they benefited consumers. So consumer welfare standard is a bit of a loaded term. It kind of depends on who's using it and how they're using it. But that the Chicago School, it was kind of a bipartisan buy-in from the judges and the academics, emphasized kind of a non-intervention, which affected a lot of the law, and moved away from the stronger teachings of Philadelphia National Bank and the literal standard of the Clayton Act. And they required that a challenger to a merger show that it is likely to have anti-competitive effects, probably will have anti-competitive effects, or almost certainly will have anti-competitive effects. So the 2023 merger guidelines tried to dial back some of that language that had creeped in with the Chicago school influence and restored the original language of the Clayton Act and some of the earlier jurisprudence.
Okay, but since they are, as Captain Barbosa would say, well, they're just guidelines. Sorry. The Departments of Justice and FTC or whoever it was could change them whenever they choose to. Yes?
Yes, they are the guidelines that the enforcers use, and business relies on them to formulate their own business strategies. They were changed in 2010, and then they got rechanged back in 2023. They've been in existence since 1968. And the guidelines with respect to mergers has been the same since 1982, with one exception of 2010. And then 2023 restored the original thresholds and market share concerning mergers.
Okay. Thank you. Other questions from commissioners? Yeah, Maria?
I guess I have a clarifying question. So for Philadelphia National Bank, the rationale and tests are not limited to mergers that occur in highly concentrated markets. It's broadly applicable.
No, it is limited to mergers that take place in highly concentrated industries that increase concentration. And the rationale is that you're going to switch the burden of proof because these are away from the government, which typically has to prove every element in a merger challenge. But the mergers that occur in highly concentrated industries are ones that are kind of inherently the most likely to have anti-competitive effects. And kind of the economists all agree that this is a particularly dangerous group of mergers and needs to have a stricter scrutiny there. And so what Philadelphia National Bank said, once you prove that this is a merger that's going to increase concentration in an already concentrated market, then we're going to switch the burden of proof to have the merging parties show that it's not anti-competitive. So that's what the court said in 1963. And that does not apply to the vast thousands of mergers. There's 16,000, 17,000 mergers a year. It only applies to those in highly concentrated industries.
Okay. Because the way I sort of read the memo, it seemed like it had more general application, but it is narrow. The application of that case is narrow.
Yes. I would say narrow, but it's limited to those mergers which are particularly dangerous, likely to be dangerous.
Thank you.
Okay. Any other questions from commission members? Seeing none?
Okay, moving on to pages 10 and 11 of the memorandum. That's where we set forth the basic merger framework, which there seems to be agreement from the commission on. This option largely tracks the Clayton Act's basic standards and should address concerns that significant differences in federal and state merger review standards would cause confusion and uncertainty. On the other hand, closely paralleling the federal merger language also risks importing decades of federal jurisprudence that have limited the Clayton Act. However, later in the memo, we have some options that would address that as well. As you may recall, this option incorporates the recommendation from Professor Landy and John Newman and former FTC Commissioner Rebecca Slaughter to distinguish the second prong of the Clayton Act tend to create a monopoly. Those folks, at least a couple of them, presented at a prior commission meeting, and the commission was persuaded by their arguments for that change to the language. The option also codifies the language from Philadelphia National Bank. And I think there was a previous general agreement from the commission that that language should be included. And you'll see on page 12, we sort of reiterate some of the stuff that we said earlier in the memo about Philadelphia National Bank. The restoration of the Philadelphia National Bank presumption is seen by many critical of the status quo as key to checking mergers in highly concentrated markets. And Professor Quokka, who was a member of our mergers and acquisitions working group, added further explanation about why he believed it was important from an economist standpoint to codify it. And again, to reiterate, while the case has never been overturned, as over the years it has weakened, including Philadelphia National Bank's holding in state law will restore its precedence. And finally, this option references the 2023 federal merger guidelines as persuasive authority as requested by the commission. I think, as you may recall, the commission or the guidelines provide detailed guidance about the procedures and enforcement priorities, and include quantifiable metrics intended to recapture the original intent of the Clayton Act. The option doesn't require the guidelines to be followed, but merely they would be persuasive authority and understood to complement California law. So that gives courts the flexibility to look at the guidelines, but is not binding them to the guidelines. And just moving on, I think we covered that one. So I would take a pause and ask if anybody has questions about this option.
Questions or comments from commission members? Okay, seeing none.
Okay, so moving on to page 14, that's where we talk about the basic merger framework and federal merger guidelines. This is another thing that the commission has seen before. This would actually incorporate the Herfindahl-Hirschman Index, the HHI, from the merger guidelines, merger guideline 1, into a proposed statute. HHI is a widely used and expected measurement of market concentration. It's been in use for decades. Courts have employed the HHI in merger cases for decades. Its definition is the sum of the scores of the market share. It is small where there are many small firms and grow larger as markets become more concentrated. Under the guidelines, markets with a HHI greater than 1,800 are considered highly concentrated, as you can see reflected on page 15. This option has the advantage of including both the more general and a prescriptive descriptor of illegality. California judges can still look to Philadelphia National Bank to interpret the merger regime, as well as how the 2023 guidelines are used. We've received several public comments supporting codifying that approach, but we've also received several public comments opposing codifying this with concerns about introducing rigidity into the analysis. And I'm gonna ask Cheryl if she wants to add something to about this option, since she is much more fluent in HHI than I am.
Herfindahl. I have to look it up every time too, to remember how to even say it. The concept behind merger guideline number 1 is to kind of operationalize the holding in Philadelphia National Bank. Philadelphia National Bank says, well, we're going to put this presumption in place if there is undue percentage of the market or the merger results in a significant market concentration. Well, those are pretty general terms, and they could turn into, each of those terms can turn into a trial itself to determine if there is a presumption. So that doesn't really help you streamline the merger challenge or reduce all of the evidence and market analysis that goes into play. So the government has for a long time used these HHIs as an indicator of the concentration of the market. Obviously, how you define the market is going to be important, what the HHIs show. But it's been recognized by the courts and the federal agencies as a very good assessment of how concentrated the market is. It's well understood how you calculate it, and it's something fairly objective that the parties can agree on. So the concept is, by having this presumption operationalized, you get to whether or not there's a presumption much quicker. And then you know that the burden to prove that the particular merger is anti-competitive is actually switched. Otherwise, you could spend a whole lot of time not knowing if you even have the benefit of a presumption and who has the burden. That's the concept.
So this HHI thing is about shifting the burden of proof from the plaintiff to the defendant.
It is the measure of the concentration in the industry.
Right.
Because remember, this presumption only applies where mergers take place in a highly concentrated industry.
Right.
So this is the filter, yes,
Right,
to
but if it-
trigger
if it-
the presumption.
If it's a concentration number over 1,800, that then says the person who wants to do the merger, they have the burden of demonstrating that it is not going to harm competition.
Right.
And if it's less than 1,800, whoever is, whether it's AG or somebody, has to demonstrate that it will harm competition.
Yes, the government typically has the burden in these cases.
Okay. Okay. And in the federal law or federal practice, it's it's 1,800 is the HHI number that flips the burden.
Yes.
And
you have to show, well, there's two different ways that the burden is shifted. One is that there's a 30% market share. And the second prong is that you use HHIs
Okay.
to measure concentration.
so it's
And
either of
you
those
need to have a concentration of over 1,800 in the industry, plus an increase in concentration of 100 points.
Okay, but it's either that there's a 30% share, or the HHI is at least 1,800, and this would augment that by 100.
Yes.
Okay. And any idea where'd the 1,800 come from?
It has been the definition of a highly concentrated market since 1982 merger guidelines. It has always been the definition of highly concentrated until they changed it in 2010. But then starting around in the 2023 merger guidelines, the FTC and the DOJ looked at it and they said, given their market experience and their experience with all the mergers, that it should be restored to the historic level of 1,800. I think it was changed to 2,500 or something.
Okay,
It got changed back to 1,800.
okay. I guess what I don't have is a sense of what that looks like. Is that like 4 big firms, each with, you know, I don't have a sense of what 1,800 versus 2,500 versus something else looks like out in the world. Yeah, okay.
Have a few
Do that.
dominant firms in a highly concentrated market.
Yeah.
You may have 5, 6 dominant firms.
Okay. Okay, sorry. Any questions or comments from commission members? Okay,
So
moving on.
sure. So I should have noted earlier at the end of each option, I have a question about what the commission would like to do with the option, but I'm reserving those questions for after public comment.
Right.
So the next issue is going back to the phrase maybe to substantially lessen competition. On page 16, you'll see that we're talking about appreciable risk. Again, this is something the commission has been looking at for some time. And then in the March meeting, basically the direction to staff is there another alternative? So I'm going to present appreciable risk, and then the language about reasonable probability as to alternatives, declaring that phrase. So you can see the language is on page 16. It would change maybe substantially to lessen competition to maybe to create an appreciable risk of lessening competition more than a de minimis amount, and also reflected when necessary on page 17. We've received numerous public comments in support of the appreciable risk standard. They believe it's a necessary reset based on what has happened over the years with the case law. They're concerned about judicial interpretations that have demanded an increasingly greater quantum and certainty of proof of anti-competitive effects than originally intended by the Clayton Act. And so they believe that the language has weakened over time. On the other hand, there's many folks who are concerned about using the appreciable risk standard because it, to quote them, introduces a new and untested legal standard, and the concern there is about uncertainty, how courts are going to interpret it, how business are how they're going to interpret it. They're concerned that there's significant risk, and concerned about the impact on the business community. So then the alternative is reasonable probability, and this is based on the research that we did on the history of the Clayton Act. And so alternatively, on page 18, we came up with the language in determining whether the merger or acquisition in question may be substantially to lessen competition or tend to create a monopoly or monopsony. The court shall not require more certainty of possible anti-competitive effects than a reasonable probability of the competitive effects. And we, as I presented the memo earlier, we are drawing that language from the Senate report analyzing the 1950 amendments to the Clayton Act, which states only a reasonable probability of anti-competitive effects is required. So, and also there's been numerous cases that have recognized that this is a fair distillation of the original intent in the Clayton Act when they've been interpreting the Clayton Act. So from a staff perspective, and I'll ask Cheryl to weigh in as well, we see this as reflecting something that's already existing law. Appreciable risk admittedly would be new language, but we're not seeing that this language would come with the risk or, or raise the objections we've heard, because it's really drawing from the legislative history of the 1950 amendments. So Cheryl, do you want to add to that?
The appreciable risks language comes from Calera, which was the bill Senator Klobuchar introduced to kind of reform the antitrust laws. It hasn't been passed. But a lot of the enforcers had gotten together and tried to come up with a standard that would kind of recapture the original robustness of the Clayton Act before kind of the Chicago school interferences. And there wasn't any particular magic words that they could come up with. They thought appreciable was a sensible reset. And then they were concerned that, okay, if we put in appreciable, then everybody's going to fight about whether there's a substantial lessening of competition. So they added the language more than a de minimis amount instead of substantially, to try and reduce, to try and eliminate a lot of a debate about whether there was a substantial lessening of competition. So that was the effort of, I think, a lot of the reformers to put forth a formulation that tried to express what Congress intended when they adopted the Clayton Act. Others will say, no, it's new language, it's not tested. Some cases have used the word appreciable when they talk about reasonable or the prospects of the anti-competitive conduct, but it's not, not a well-developed set of language on it. So the commission asked us, well, can you try and express this concept in layman's terms? And I think it became rather obvious from a lot of the cases, as well as the legislative history of the Clayton Act, that what Congress intended when it adopted the Clayton Act was that there be a reasonable probability of this substantially lessening of competition. Everybody kind of understands that reasonable probability is somewhere between a fat chance and a certainty. And the cases have kind of consistently used that language, reasonable probability. So it's not really a reset at all. It just borrows from the language of existing, as well as the language from the Senate report on the Clayton Act amendments.
But we do believe, even though it's recognized in existing case law, we do believe that codifying it for California law would add clarity along the lines that the folks who came up with appreciable risk would, so that things aren't weakened. Any questions?
So, this section is talking about a choice between appreciable risk and reasonable probability.
Correct.
So the language on page 16, if you chose reasonable probability would see maybe to create a reasonable probability of lessening competition more than a de minimis amount. Right?
No, the language on reasonable probability is reflected on page 18.
I saw that, but I didn't see, and now
So we
is
would,
the language on page 18 attempting to clarify the language of substantially lessen competition?
yes. However, so the way it would work is if you decide, no, don't want to do the appreciable risk, the language would, in the basic framework would stay the same. And when we were looking at this, we thought the cleanest way was to introduce a new subdivision that was specific to reasonable probability. And I don't know if Sarah do you have anything to add to that? We can't hear you.
Can't hear you very well.
Right, so the courts shall not require more certainty of possible anti-competitive effects than a reasonable probability of anti-competitive effects. Is that
Okay,
helpful?
no, I got that. I'm not clear on why you would add a new subdivision to use the term reasonable probability as opposed to up in like the language on 16, substitute reasonable probability for appreciable risk.
The reasonable probability, I think, was an alternative to appreciable risk. We wanted
Yes.
to clarify the original language.
Right, but if you want, why would you need to clarify appreciable risk? I thought these were two alternative ways of talking about the
Correct.
likelihood of bad outcome. Why would you then not just take that phrase on page 16 and put in, create a reasonable probability of lessening competition more than a de minimis amount? Why would you have to?
Cheryl, do you have any thoughts on that?
Yeah, I think the intent was to stay as close to existing Clayton Act language as possible. And so with a reasonable probability, by utilizing the original Clayton Act language, we've all then made it clear that the reasonable probability only relates to the certainty.
Right.
And so there's no debate about whether it relates to the quantum of anti-competitive effects, but only to the certainty.
And I would echo that. I think the original point was to further explain the original language and not by replacing it but by adding additional verbiage to explain it, whereas appreciable risk is really changing it.
Well,
But-
okay,
Exactly.
so these are not two alternatives. One alternative, one would be to say appreciable risk of lessening competition more than a de minimis amount, where you're speaking to both the likelihood and the quantity of harm. Appreciable risk,
Yeah.
de minimis amount. The other one, the alternative with reasonable probability is to attempt to, in some manner, clarify the maybe to substantially reduce the lessen competition, something like that.
That's correct.
Yeah.
Yes, it's just reasonable probability only goes to the certainty of the possible anti-competitive effects,
And I
not
believe
go to the quantum.
Yeah, no, I got that, but it sounds like you're using them in two different ways. One, at least as I read page 18, you're using reasonable probability to clarify the maybe substantially to lessen competition, the Clayton Act language, as opposed to changing the Clayton Act language to say appreciable risk of reducing competition more than a de minimis amount.
You're also using it to clarify the second prong, tend to create a monopoly or monopsony,
Yeah, no, I got
which
that.
has an independent analysis. So you're saying that you just have to show a reasonable probability that it may tend to create a monopoly.
I got that. I got that. It appeared to me that on pages page 16 and 17, I guess, that you are striking out the language substantially less than competition or tend to create a monopoly or monopsony. You're striking that out, and you are substituting appreciable risk of lessening competition more than a de minimis amount,
Correct.
as opposed to with reasonable probability, the substantially less than competition, where is it? Substantially less than competition is still there, but you're saying, by the way, that's a reasonable probability.
Correct.
Yeah.
Yeah, so it's basically
So
defining what substantial.
One is defining the current law, the other one is replacing the current law.
Correct. Okay.
Yes, yes.
So those are not two alternatives. I mean, they're not two variations on the same
I
thing.
think by alternatives, you mean that the commission would pick one or the other. I don't think they would work together, although maybe Cheryl has a different view on it. Maybe, could they do both? Would it make sense to have appreciable risk and this? No, that doesn't work.
What I'm
because-
saying is,
yeah.
I thought the alternative was, if you're going to say appreciable risk versus reasonable probability as the likelihood of bad outcome,
Oh, I see
Okay.
what you're saying.
right? Isn't that what you're saying? Those are two different definitions of the likelihood of a bad outcome, right?
And I think the staff's understanding of the commission's original request to the staff, which brought about the reasonable probability, was to create an alternative to the existing options. And our research and understanding found nothing else that was as compelling as just modifying the original language with what else we discovered. So we had the appreciable risk present from the beginning as an alternative, and then this was not another real alternative to that, but it was an amendment of the existing law to clarify it, if that's helpful.
Okay. So,
Yeah, I think Sarah captured it. And
Okay.
sorry if that was
yeah, okay.
confusing, because obviously it was.
Because they sound to me like two different ways of saying the same thing.
A lot of this is all kind of different ways of trying to say the same thing. We're just
Yeah.
trying to figure out what would resonate the best with the courts and understanding what we are asking them.
Yeah,
to
no,
do.
I mean, I tend to think that reasonable probability is a little more understandable than appreciable risk.
That is grounded in the historical record
Yeah,
of.
yeah, no,
of the
no,
bill.
I got that. I'm just wondering why, if that's what we want to use to help courts identify the likelihood of a bad outcome, do we say it in the language in this the question, where is it? Maybe to substantially lessen competition, or why don't we, I mean, why wouldn't one then say, maybe to create a reasonable probability of lessening competition, or a reasonable probability of lessening competition more than a de minimis amount?
I believe the intent was not to replace substantially to lessen and thereby removing all of that case law, but to reinforce the case law by further explaining what we understood that
Okay.
case law to be.
So, okay, so the clarifying definition, like on page 18, could have said, shall not require more than a reasonable probability, or could have said more than a, what was the other thing we said?
Now,
De
so
minimis
appreciable
amount.
risk
Appreciable
doesn't,
risk.
yeah, so appreciable risk is meant to be different completely from the original substantially. So those two can't coexist. They're different and they're intended to be different, whereas reasonable probability is meant to complement the substantial.
Okay. well,
I think if you talk to the formulators of Calera, they would say they're meant to say the same thing. they are meant to talk to the judges who require too much evidence and too much certainty of the negative
Right.
effects of the
Right.
merger.
Got that.
And they felt that by putting in different language, that clearly communicated to the judges that they were requiring too much certainty and that they had to dial it down. And I think a lot of people said, well, that's good, but it's a new language and there's not a lot of judicial body of law to support that. So we felt the reasonable probability is a more direct way of telling the judges, when you're looking at the certainty of possible anti-competitive effects, don't require more than a reasonable probability. And it speaks to it very directly in almost layman's terms.
Okay, so it's a way to leave the Clayton Act language in place, but give guidance to the court as to how they ought to interpret it.
Yes.
Yes.
Okay, well, I guess I just keep wondering if that's how we wanted to interpret it, why wouldn't we put it in the actual language?
It would be, and, well, I'm not.
Well, no, all you're saying is court shall not require more than a reasonable probability, as opposed to saying, up in wherever it was, maybe to substantially lessen competition, rather than saying that, you could simply put that language, substitute it for substantially lessen.
But you also have the second prong tend to create a monopoly.
Oh, yeah, no, I got that too.
So, yeah, so that.
I'm not disputing that. I'm saying, as opposed to leave the Clayton Act language in place and sort of define it, this is suggesting, and then to clarify for courts, you're suggesting reasonable probability should be, we're telling courts that that's what you should use to clarify what substantially lessen competition means.
But it also clarifies what may be to tend to create a monopoly.
Yeah, yes, no, I got that. I'm not leaving monopolies out. But all I'm saying is, I guess I'm not sure why you wouldn't put, rather than keep substantially lessen competition, which the Clayton Act language, and then have something that says, oh, by the way, here's what that really means, versus put that language in place of, or in lieu of the Clayton Act language.
If I may, I think it's an option for you. I
Yeah.
think the staff's design and putting this in there was retaining the existing language and reinforcing it with the additional language, as to not to create more uncertainty by deleting it.
If I can add, I was going to say, we've talked a lot about adhering to the Clayton Act language, so there'd be more consistency and people wouldn't think that it's a totally different standard and would create uncertainty. So leaving that language in there, I think, is a good idea.
Okay.
It makes it more, I don't want to say defensible, but it hews closer to the standard. But the other thing is, I mean, these are just two options. Another option is not to have either of these.
Right.
That's
Yeah,
correct.
right. Yeah.
Right.
Yeah, I agree with Commissioner B to keeping the old language. And the backdrop of that is, we have to appreciate the fact that what we did on single firm conduct barely passed the Appropriations Committee last week. I mean, there was so much uncertainty with what we were proposing that they actually had to give up the private right of action just, I think, on Friday or Thursday. So there's a lot of controversy out there, and people are concerned that we're unmoored from federal law and all that, and just unmoored from the old standards. So to the extent that we can call back the old language and keep it, it kind of like shows that we're on firmer ground rather than trying to stake out new aggressive ways of antitrust enforcement.
I understand. No, I think that, I got it. Yeah, David?
Just a clarifying question about where we are in the discussion. Are we only asking questions about the proposals now? Do you want a proposal for which one of these proposals we should do?
The idea is that we would go through everything, hear public comment, so you can digest that, and then go back to the questions.
Okay.
Yeah, okay. Sorry to
Then
digress.
can I ask a question about
Absolutely.
where we are now? Either Cheryl or
Sarah.
jump ball question for whoever wants to field it. Talk to me more about where we got, not where we got, what the afterlife was for the language that you found on page 4 from the Senate report to HR 2734. There were a couple of references I think in Sharon's points about the further life that this reasonable probability language had in case law. Talk to me about that.
I'm sorry, I didn't hear all of your question. The
Yeah,
language.
so
Sure.
talk to me about the further development, use, acceptance, or not of the reasonable probability language that's on page 4 of the memo.
Oh, okay.
What happened to it after it showed up in this Senate report? Did it die there? What happened to it afterwards?
It continued to be restated in case law.
Oh, yeah. Almost every major case recites the use of, cites the Clayton Act, and it says in interpreting the Clayton Act, you shall not require more than a reasonable probability. And this statement, reasonable probability, appears, that clarification about reasonable probability appears in the report supporting the adoption of the Clayton Act language.
Okay, so talk to me about the conventional wisdom sense of what's the consensus among the various experts, academics, people who are knowledgeable in this area, and probably having to carve out the Chicago school, which I'm sure hates this, but accepting them, what's the acceptability of this language in the broader antitrust community?
I would think whether you're a Chicago school adherent or a Chicago school critic, that reasonable probability has been the accepted test of certainty and the accepted modifier of that Clayton Act language.
Okay.
It's in numerous cases, the courts consistently refer to the evidence as meeting a reasonable probability of substantially lessening competition.
Okay. So when I'm looking at page 16, and the memo's presenting the appreciable risk phrasing as an alternative to reasonable probability. And again, I think it was in Sharon's comments that a bunch of folks got together to try to hammer out this phrase, acceptable, appreciable risk. Can you talk to me about what the rationale, like why was there a perceived need for creating this new term appreciable risk when reasonable probability has always been there? Like why reinvent the wheel?
I think there was a lot of practitioners or enforcers in particular who felt in challenging mergers, the courts were requiring them to prove the anti-competitive effects of a merger that hasn't taken place with almost a certainty or a high probability, or requiring that it probably be anti-competitive. But the intent of the Congress when they adopted the Clayton Act was to get rid of further consolidation in its incipiency before it happened, before you can, at a time when you can still unscramble it. So that's why the Clayton Act adopted this incipient standard where you're basically making forecasts about what the probable anti-competitive effects are. If you require an enforcer to show it's probably going to happen, that's almost impossible. So, or it's likely to happen. That means if you make the burden that high, the enforcers are probably gonna lose. The challenge is probably not gonna succeed because it's kind of a very complex area and uh, the shifting of a higher burden makes it more likely that you're not gonna be able to meet the burden of proof.
That's helpful. I was wondering what the problem was, and that now with that explanation, it strikes me that that coming up with the term appreciable risk is sort of solving the wrong problem. The problem wasn't in the definition or the terminology. It was in the understanding and the application of reasonable probability. So it strikes me that going with appreciable risk, it's just creating the same problem. You have the same definitional problem. You'll have the same application problem. The courts that want to under enforce antitrust will just interpret appreciable risk in the same manner narrowly that they did reasonable probability. So you'll wind up back with, it's the same problem. So you'll wind up in the same place.
And Commissioner, if I might add, even with the same language where the discussion centers around it being included in California law, which has a different tenor to the antitrust laws or would. So the interpretation would be different even with the same language within California law.
So that actually inspires another question, which is I think we were talking generally about the prevalence or acceptance of reasonable probability, both as a term of art and as a concept in case law in general. Is there any differentiation between federal and California case law, either in terms of acceptance or application or usage for that term?
All the cases would be interpreted under federal law.
Yeah.
So it's
Okay.
the same.
I'm just like we've
Okay.
encountered places in this study where California and federal courts diverge in their interpretation and application of the same terminology. Is that the case here?
They wouldn't because they're only allowed to interpret it under federal law. But in other cases, and Cheryl, if you could help me out, there's a general sense that California is, at least when we're talking about the Cartwright Act in general, it's interpreted more favorably. Word.
Yeah.
More pro-consumer perhaps is the understanding, but California would not have cause to interpret the federal language under California law, so they would be bound by the federal interpretations.
So there's no daylight.
Yes,
Reasonable probability is I think a term of art that's used in a lot of different laws in California. And I think, it's between a hunch and certainty, and it's kind of in the middle. It's less than, I think there's actually case law that says it's less than more likely or more probable or probable.
So it sounds like it would be accurate to say that this term reasonable probability is widely understood and applied in the same manner by federal and California courts. Is that fair to say?
I think that would be fair to say.
So if we use that term, no one would be confused by it, right?
it would be applied under different circumstances, but it's not
And
new.
everybody would know
Right.
what it means, right?
Yes, correct. They would have other places to look to understand what that means.
Thank you. I have no further questions.
Any other questions or comments from commissioners? Seeing none. Okay, next. This is the purpose statement.
Okay, so turning to page 19, that's where we set forth the purpose statement, which is the commission had previously directed staff to include, to Sarah's point about California law being different than federal law. You'll see in subdivision C, there's the language that the California Supreme Court has determined that the Cartwright Act is broader in range and deeper in reach than the federal Sherman Antitrust Act. So to underscore the difference between state and federal law and how California has a broader interpretation. At this point, this language is sort of a placeholder for a purpose statement. It is in AB 1776. So, and as we discussed previously, it's not the end of session yet, and so we're not exactly sure where the legislature is going to land with the language. So, but the direction of the commission is that there should be something similar to what was done for single firm conduct for mergers. And also there's the language on page 20 citing to another California Supreme Court case stating court shall liberally interpret California's antitrust laws to best promote free and fair competition and be mindful that California favors maximizing effective deterrence of antitrust violations. Or any questions about
from
this language?
commissioners? I guess I'm not sure what the last phrase is intended to mean. Favors maximizing effective deterrence.
That's actually from the
the-
case
I
law.
remember there's a case law, yeah, but what is it, what's it mean?
This is the policy decision between under enforcement and over enforcement. You're
Right,
going to err
right,
on
I
one side or
remember
the
that.
other. Yeah.
And it sounds like it's telling a court, well, if you're not sure what to do, err on the side of over enforcing. And that, I don't know, bothers me.
Why?
If a court's not sure what to do, the court's not sure what to do. I
Tie goes to the runner.
I don't know.
Commissioner, if I might add,
Yeah.
one of our public comments this round spoke to the false positives concern. Professor John Quokka wrote that the federal judiciary has erred on the side of I'm going to get those wrong, but they've erred on the side of under enforcement, and whereas that's actually caused more problems. So I think what this is getting to is saying we err on the side of over enforcement to correct.
Yeah, this is memo 29 supplement
Yeah, I
2.
remember.
Empirical evidence makes clear that it is not false positives, but false negatives that have compromised current merger enforcement.
Yeah, I guess it's the false part that bothers me, and I'm not quite sure.
The
what to
question
do.
is, what are the consequences if you're wrong? So if you're a judge and you're not sure, this kind of goes both ways. The incentives to be wrong in the direction of over enforcement are it's more beneficial than the incentives in the direction of erring on the side of under enforcing. So you have worse downsides if you under enforce than if you over enforce. There will be downsides in
both.
either direction. Yeah.
Right,
The
right.
question is, between two bad options, which one's worse? Which scenario has the worst societal consequences if I'm wrong? Because again, this whole exercise is about predicting the future.
Yeah,
right?
Yeah, no, true.
Which good
Right.
luck with that, right?
Yeah. Okay.
Courts are going to get this wrong. The question is, how much worse is it if they get it wrong in one direction or the other?
And if they approve a merger that shouldn't have been approved because there wasn't sufficient data or something, the outcome of that is
Is a monopoly.
competitive.
Yeah.
Is
It's
bad,
anti-competitive.
hard to fix.
Yeah.
And I think Professor Quokka's paper he has a book in which he reviewed very substantial mergers over several decades. And he found that in 80% of those mergers across all sorts of industries, the prices increased in 80% of them. So the conclusion that he reaches is that these mergers were improvidently approved and that the damage is being done to consumers through these mergers. If you look for if you look where they have wrongfully ignored some, I think one of the commentators points out to a case involving Amazon's merger with iRobot.
The vacuum people.
Only false, is it a false? Positive, I always forget.
Yeah.
but they say it was wrongfully challenged. What happened in that merger is little iRobot wound up being sold to its manufacturers, so it was actually more pro-competitive. So it wasn't a very good example of
They
a
then went
false
out of
negative.
business.
Pardon?
They went out of business.
Well, the company then bought them, Picea.
Yeah.
Yeah.
iRobot doesn't exist anymore, as far as I know. Yeah, iRobot's gone.
Oh, okay.
Yeah. It didn't work out well for them.
Okay. Okay, sorry to dive. Anyway.
So I think that we made it all the way through the memo, so we could move on to public comment unless you want to take a brief break before.
Can I ask a quick
Sure.
question on the purpose statement? So in there, it says the federal Sherman Antitrust Act, so we would change that to the Clayton Act for,
You know, I
Yes.
wrote that down as a note to myself, and I was intending to talk to Cheryl about that. Do you think are you prepared to answer it, or should we talk?
Sorry, I didn't hear the question.
So if you look on page 19, subdivision C, so we have the language about the California Supreme Court has determined the Cartwright Act is broader in range and deeper in reach than the federal Sherman Antitrust Act. I think Commissioner B's question is, would that be changed to the Clayton Act? And I'm kind of gonna guess that it would not, because I think the case was decided in the context of the Sherman Act, but I think maybe we could look at, I think we need to look at rephrasing this one because it is pretty specific to the Sherman Act.
Yeah, the Cartwright Act isn't broader than the Clayton Act. They're totally different animals. We don't have any merger language.
Yeah,
Right.
but I think that the concept is that California has tended to be more progressive in its interpretation of antitrust law. So I think this needs to be rephrased to reflect that.
Okay.
State law in many states is stricter in antitrust than federal law.
Okay. And this was just lifted from the single firm
Yes,
language. Okay.
yes.
So it might need to be rephrased to have a better context for mergers and acquisitions.
Yes.
Okay. Any other questions or comments from commissioners? And it's just almost 2:00. I believe Commissioner Huebner was going to step out for a short while. Is that still correct? And
Yes.
rejoin us sometime between 2:30 and 3 probably. Okay, should we move to public comment?
Unless you think this is a good time to break for a comfort break.
Oh, how about you want a 10
Go
minute,
for about 2 hours.
2 hour comfort break? No, you'd already be back in the Bay Area by then. I want to take a 15-minute break.
Yeah, that
Okay.
sounds good. Thank
All right.
you.
Okay. We are now back in session and it is time for us to start hearing public comment. So,
Before we launch into that, I just wanted to mention that we did receive a substantial amount of public comment, which is on the commission's website. We have a binder
Yeah.
available for anyone in the room who wants to look at it. I'm not sure that everybody who submitted a comment is going to also make oral public comment, so I just wanted to acknowledge and thank folks for
yes, I
for
agree.
submitting comments. Very
yeah,
helpful.
No, it's very helpful. Gives us good context. How many, I think we'll probably do in person first.
Yes.
And then how many do we have? We have 3? Okay. Yeah, it'll probably increase, yes. Okay, so who wants to get up there first? All right. And keep the mic close to you. if you can. There you go.
Okay, okay, yeah.
There you go.
Yeah, I can hear that, all right. Okay, thank you very much. My name is Kathleen Foote. I retired about 3.5 years ago from the California Attorney General's office, where I worked for 34 years. The last 20 of them, I was the chief of the antitrust law section. So during that time, I reported pretty directly to 5 consecutive AGs, from AG Bill Lockyer to AG Rob Bonta. I was also, during some of that period, the chair of the Multi-State Antitrust Task Force, which is part of NAG and embraces all of the, essentially the staff people, the staff antitrust people in the AG's office, where a lot of coordination is done. And I was also very active in the ABA leadership kind of group during that time, speaking about state antitrust issues during a long period in which we were doing our best to elevate the essentially the acceptance and credibility of state antitrust enforcement in what had previously been a very heavily federally dominated world. So my purpose today really is to give you a kind of a real world perspective on the merger enforcement experience that we had during particularly my last 20 years there, over the long term, so that you're essentially to bolster what is happening now is unusual, but very unusual with the changes during the Trump administration. But there's a kind of a long history, I think, behind that also warrants the kinds of changes that you're considering. And I hope also to get into some of the comments and concerns that people who have been writing comments into you have. Essentially, during all this period, most of the antitrust, of the merger enforcement work is quite collaborative. We work with other enforcers and relied heavily on the feds, in particular, DOJ and FTC. And when I say DOJ in this context, it's the U.S. Department of Justice Antitrust Division, not our own DOJ. Most of that involves gathering factual evidence and fitting it into an economic analysis following the federal guidelines, whatever they were at the time. Certainly the 2023 federal guidelines, California, New York, and a number of other state AGs had a fair amount of input into those and submitted formal comments very much in favor of the changes and of the clarifications that those guidelines related to, such as Philadelphia National Bank and so on. By and large, our work was in the hands of the professional staff up until pretty close to the end, and with a lot of mutual respect at the staff level, and a good bit of similar thinking on most things. The need for active state AG involvement is very high with regard to merger enforcement. I mean, other enforcement too, but merger enforcement in particular, as mergers have become more and more a part of daily life almost, certainly in the California economy. It's really central to the AG's mission under antitrust to protect the California economy. And even at their best, the feds can be counted on only up to a certain point. Their resources are increasingly stretched. Bill Baer, who was the antitrust chief in the Obama administration, spoke quite openly about that and about the fact that they were essentially forced into settlement of cases that they would have preferred to litigate all the way to the end, and to the fact that they that essentially their investigation had gone from raising questions about 7 to 6 and 6 to 5 mergers to the 4 to 3 and 3 to 2 kinds of mergers. Not because they wanted to, but because that's all the resources they had to. So they were certainly quite eager, at least under that administration, for the kinds of assistance that state AGs could give. So resources are one. Also, bless their hearts, their knowledge of California realities, especially just the very size of the LA metropolitan area. We're off base, sometimes almost laughably so, and at times not. And then the sensitivity, particularly when talking about divestitures in working out a settlement with divestitures. California had always, for reasons that you're all probably familiar with concerning labor, a focus on whether there would be restrictions on labor in the course of all of that. You don't find that kind of thing. Briefly, that became a part of the DOJ equation, FTC equation, at least in the Biden administration. But it certainly had not. It was a new concept that California's participation brought to thinking about all of that. All of that said, when I look back over it, we were averaging about 5 to 6 significant merger matters per year. And when I say a matter, I'm really mostly talking about investigations that either ended up simply ending with no action or ended up in some kind of a consent decree with divestitures, and in some cases simply behavioral relief. Very few actually involve going into litigation. In terms of resources, when I started, we had 14 lawyers in our unit. When I finished, we had 26. I know that there are more than that now, at least on a temporary basis, because of the kind of load that AG Bonta has been facing. And certainly happy that the legislature has moved things up. I think with permanent resources, that number could increase, but not by orders of magnitude. So you're really not talking about a great number of all the merger matters that there are out there that you could look at. There's a lot of very careful selection for what's most important for California policy, for California consumers. The kind of loose criteria that we would use, and I'm sure is still used, there were several kind of common sense things. Are there local markets involved? Geographic, as I'm sure you know by now, it's all about market definition, and there are geographic markets and there are product markets that define where the concentration is and what the concerns are. So local markets were our specialty. I'm sure they still are. Grocery stores, hospitals are only 2 examples. There's a great many more. Healthcare, certainly other kinds of healthcare institutions need to be local. Then there are product markets, surprisingly, that are uniquely California. Gasoline, for sure, has its own formulation. School textbooks are uniquely California because they are prescribed by the state. And the fact that there may be other American history textbooks out there for 8th graders doesn't mean that they can just simply willy-nilly come into the market and be counted when you're looking at what concentration may be looking like. State regulatory interest often cropped up, waste disposal sites, telecom, healthcare again, and special consumer impacts as well. Of course, there's overall impacts and geographic impacts on consumers. Way back in around 1998, at one point, the states, through NAG, put together their own guidelines. And at that time, At one point, I went through them and compared the federal to the state ones. And they've never been readopted. It's all kind of gone by the boards. But two differences of note. One was the NAG guidelines put a little bit more emphasis on skepticism regarding so-called efficiencies. And the other, I think, quite significant and very sort of state-oriented was vulnerable populations. A special look at vulnerable populations, which is certainly an appropriate area for a state AG who covers so many other areas of law that affect vulnerable populations would be looking. So that includes obviously ethnic populations, it includes the elderly, lots of laws about that, children, disability, low income, people who rely on only public transportation. Those are some of the things that are kind of flagged for special attention under those state guidelines. And then finally, value added. What's the value added of California being involved in this? Given all the other things that there are to do, California has never been one of those states that has just sort of signed on to a merger case and expected not to play any particular role. A lot of them are filed in California, and those are, there has to be a presence. And there are others, there's special knowledge and so on is very much part of that. So why do we need our own law, given our level of activity in federal? First, obviously, we can't count on federal law to produce a result that aligns with California knowledge or California-specific policy concerns. Another painful but very true point to be made is when the AG, on rare occasions, takes action to block a merger independently after the US DOJ or the FTC has decided not to, the merging parties use it to try to discredit the states. They use the fact that the feds have decided to walk away, or in some cases decided to take a consent decree. Use it to discredit the states. That happened way back in 1998 in the Sutter Summit merger that the AG challenged on his own after the FTC had decided not to do anything. It influenced the court. There's no question but that it influenced the court. It happened again in 2017. AG Becerra brought a standalone case against the Valero's acquisition of the Plains All-American facilities in the North Bay. That one we actually won, but not before the parties knocked themselves out to try to discredit the state's action. That was a California-only thing. It didn't involve other states. It is actually one of the kinds of mergers that might very well, had there been a California merger law, have gone under that, since there were only two FTC commissioners and they couldn't talk to each other because of the various rules about doing that outside. Yeah, you know all those. I don't have to go into it. Then under the first Trump administration, the Justice Department itself attempted to discredit the states in the T-Mobile-Sprint merger. That was under AG Becerra. More recently, as another issue, the Justice Department has entered into some grossly inadequate merger settlements or rushed into some favored mergers, essentially sort of semi-secretly attempting to avoid state scrutiny. They've stopped their own investigations early and sort of ended the collaborative investigative approach that has been used. So all of those certainly point to Although I am sure that continuing to work collaboratively will continue, if for no other reason than the Hart-Scott-Rodino materials and the AB 25 materials are together. The professional staff continues to value each other, respect each other, and so on. And of course, the states themselves work together, and at times still in a bipartisan way. Hopefully that will return even more sometime in the future. So we do need our own law. Why do we need our own standards? I think you've been hearing a lot about that, so I don't have to add a lot to it. The progressive weakening of the federal merger law is a real thing. We have certainly encountered that ourselves. We also need our own courts if we are going to be pushing harder on the standards, as you're obviously considering here. Needing our own courts for accurate interpretation is very important. It has happened repeatedly that we've seen federal courts in dismissing a Sherman Act claim also dismiss a companion Cartwright Act claim. Now, this is not in the merger context, obviously, because there is none, but in other areas, they dismiss the Cartwright Act claim and rule incorrectly that it's basically just the same as the Sherman Act. So that happened most recently during my recollection in the Epic versus Apple trial court ruling by Northern District of California Court in 2021. Although happily the court did cite the Unfair Competition Act 17200 as having different standards. Another thing to keep in mind that I'll just point out is that many California merger cases, even under a new California law, will likely be filed in federal court as a companion to a federal court case. And that's because the tradition of collaborative work during this long investigative period is going to continue. It will undoubtedly continue on some level with the feds, and it will certainly continue with other states. And the only way you can be in court with those people together is in a federal court, even if you are bringing a state claim in addition to a federal claim. So federal judges.
Can you wrap up?
Yes, I will. So federal judges have the authority for that. I want to just note that the principal objections, I hope that this is not needed or that it will be two standards. I think those have been addressed by staff. The false positives issue is one that California courts have been very clear about. And it was first raised in the federal court not in a merger case, actually, in a monopolization single party case. I think that the clarification of standards that you are looking at so closely is super important to help the courts with all of this. And I really congratulate you for doing it, and thank you for the time.
Okay, thank you. Are there any questions for this presenter? Seeing none, thank you. Who would like to go next? All right.
I think I'm in position.
Welcome back. You talk.
yeah, can you
Stay
hear me?
close.
Okay, yeah, I'll be sure to stay close. Good afternoon, Chair Simpson and commissioners. My name is Ben O'Brien. I serve as the Director of State Policy Analysis for California Life Sciences. CLS represents over 1,300 pharmaceutical, biotechnology, medical technology, and academic research institutions across the state. And I'm here today to reiterate our serious concerns with the Commission's draft options in Memorandum 2629. These types of proposals represent an existential threat to the continued development of innovative treatments and cures in California, as this process is underpinned by mergers and acquisitions. California already has robust tools to challenge problematic transactions through existing mechanisms under federal and state law. The California Attorney General has independent authority under the Clayton Act to sue to block a merger, in addition to the ability to file suit using the state's unfair competition law or seeking an injunction to block a merger under the Cartwright Act. This is on top of the 2023 federal merger guidelines, which provide a more aggressive analytical framework that could inform such litigation. SB 25, effective January 1st, 2027, further gives the Attorney General real-time access into federal Hart-Scott-Rodino filings for covered California transactions. Together, these recent reforms and existing mechanisms provide meaningful oversight, and no demonstrated record of M&A-driven harm in the life sciences has emerged to justify going beyond them. I would also point to recent actions taken by California's Attorney General demonstrating that the office already can and will pursue merger conduct they feel is unlawful. Now consider what these proposals would do to an industry that depends on M&A to function. Deloitte's 2026 report on the sector, a widely cited analysis of biopharma R&D, found that it now costs $2.7 billion on average to bring one new medicine to market. 9 out of 10 drug candidates fail before they ever reach a patient, and more than 80% of California's life sciences companies aren't yet profitable, depending entirely on outside investment, including mergers and partnerships, to keep research alive. M&A isn't a side strategy in our industry. It's the primary mechanism that allows a small biotech with a promising molecule to reach patients. Data supports this. An empirical analysis by the Cornerstone Research Institute across 3 decades found that drugs in development that undergo M&A are nearly twice as likely to reach patients as non-acquired ones. This is an effect that's even more pronounced for novel drugs. Under the current ecosystem, FDA drug approvals have climbed from about 25 a year in the early 2000s to roughly 50 a year since 2018. Additionally, the number of new drug applications filed with the FDA has increased in the last decade compared to the previous. Further analysis finds that between 2015 and 2021, 65% of FDA-approved drugs underwent a merger or acquisition. This pipeline of innovation is real, and it's being fueled by exactly the kind of transactions these options would put at legal risk. Specifically, options 1, 2, and 3 lean on market share and concentration thresholds to presume a merger is illegal. These thresholds won't work in our sector. Markets for rare diseases, orphan drugs, and cell and gene therapies are narrow by design. Sometimes there are only 1 or 2 approved treatments in existence, not because of anti-competitive conduct, but because that's how targeted science and the FDA approval process works. Applying a generic concentration threshold to that kind of market will flag exactly the transactions that should be encouraged as presumptively encouraged as pro-competitive. Option 3 makes this worse with its rebuttal standard, which only lets a company defend a merger using benefits that show up in the same narrow market. In our industry, real merger benefits routinely show up somewhere else. Confining the defense to one narrow market artificially limits a court's ability to weigh the full range of benefits and drawbacks of conduct. Option 4's appreciable risk standard raises a different problem. It's untested and lacks guiding case law. Again, we urge the Commission to prioritize consistency with federal merger law in whatever recommendation it chooses to develop. A patchwork of state standards doesn't help consumers or businesses. I'd just like to close by saying how impactful California's life sciences sector is on the state. In the last year, it contributed $20.4 billion to the state in state and local tax revenue, generated an economic impact of over $396 billion, and directly employed more than 336 Californians in high-skill, high-wage jobs. This success rests on a legal environment that is stable and realistic about how the industry operates. We ask the Commission to preserve that balance in any future proposals. And again, thank you for the opportunity to comment. We also submitted written comments.
Thank you. Are there any questions for this presenter? Seeing none, thank you.
Got to bring this down then.
We get you a
Shouldn't go out-
stool.
shouldn't go
I'll
after
get you a
this.
stool to stand on, you know.
I'll stay on this binder.
I'd be the same place.
Good afternoon.
Welcome
Eric
back.
Nixon with Kroll and Mooring here on behalf of the California Chamber of Commerce today. Thank you for allowing us to appear, and many thanks to the CLRC staff, Sharon and Sarah in particular, for getting our written public comments published late last week, even though it was a bit late. So we appreciate that. And our written public comments do cover the major issues we see with the proposals in the latest memo. So I don't want to take up too much of your time today. But I think the starting point for your continued analysis of the M&A proposals is to consider the AB 1776 experience, as Commissioner King noted earlier this morning. The bill has been amended several times in both the Assembly and the Senate, due mostly to concerns about uncertainty and specifically about differences between California and federal law. And I think we need to take those concerns into account when considering an M&A provision. Along those lines, the quote-unquote basic merger framework set forth in the memo is not basic in our view. It provides 3 separate tests for the legality of a merger, and then it also, of course, invokes the federal merger guidelines. Now, I assume that those 3 tests are different, and the memo does talk about a sliding scale, but it's not, at least to me, clear how those standards are different and how they might interact with one another and how this kind of sliding scale might work. So under this framework, opponents of a merger will really have the ability to sort of pick and choose the test or tests or guideline or guidelines they will use to challenge a merger. And the merging parties will then have to defend their transaction under multiple legal standards. That is not a fair and balanced merger policy. It will inhibit mergers and acquisitions due primarily to the uncertainty that it creates. Now, quickly, given the conversation earlier about HHI, it is a tool. It is not the end-all be-all of merger analysis. And as we point out in our latest submission and in previous comment on the M&A proposals, there are a number of transactions that have not been challenged over the years, that have not been challenged by the federal government or others, despite the fact that they had an HHI above the thresholds that are currently being proposed in the memo. And the precise reason for that is because mergers need to be evaluated on more than just a mathematical equation. They need to look into the unique facts of each transaction. So elevating HHI to a presumption is problematic. On the reasonable probability issue, I think it is fair to say that that standard has been widely used over the years by courts and others. The question in my mind is a reasonable probability of what? The quote-unquote lessening of competition in more than a de minimis amount is a new standard. It's untested. And as far as I know, there is no economic underpinning suggesting that setting the goalpost there, as opposed to, for example, a substantially lessened competition standard, is the right thing to do. Finally, CALERA, it's a federal bill. We've talked about it before. It has never gotten much traction for a lot of different reasons. And it certainly has not been close to passing. It should not be our guide for the laws we endorse here in California. Now, to be clear, again, Cal Chamber favors rigorous merger enforcement. And I agree with Ms. Foote 100%. California certainly has an important role in doing that. The current framework allows California to step up when there is a need, and our AGs over the years have been incredibly successful in doing just that. So adopting M&A proposals, any of the proposals in the latest memo, threatens to upend this balanced ecosystem with really no demonstrated need and at an enormous cost to California. Thank you for your time, and I'm happy to answer any questions you might have.
Okay. Any questions for this presenter? Seeing none. Thank you.
Thank you.
All right. Hello, hello. Good afternoon, Chair Simpson and commissioners. My name is Loyal Terry, and I'm here representing Economic Security California Action and the thousands of Californians who are feeling the impacts of corporate concentration on their everyday lives. Commissioners, I'd like to thank you, and especially your staff, for your continued thorough and transparent work on this issue. We've been following the study closely with our anti-monopoly coalition partners, many of whom you will hear today, including labor, consumer advocates, business leaders, and antitrust experts. The promise and vision of a fair and competitive economy is one where workers take home wages that reflect their labor, small businesses compete fairly, and consumers pay prices set by markets rather than monopolies. But with federal antitrust enforcement being eroded and corporate power consolidating at historic levels in our state, the world's fourth largest economy, we can no longer afford to outsource merger oversight to Washington. Maintaining a strong and competitive economy depends on California having the legal tools to enforce that vision within our borders. Our Attorney General has been active in opposing potentially anti-competitive deals. Earlier this year, AG Bonta filed a suit to block a behemoth broadcast merger between Nexstar and Tegna, which would give one company control over 265 TV stations, a merger that was waved through by this current administration. His office is also leading a 12-state lawsuit to block the Paramount and Warner Bros. Discovery merger, which would crush the state's film industry while giving one company control over both CNN and CBS. These are exactly the kinds of mergers a strong California merger law could address. But California has no law that explicitly allows mergers to be challenged in a state court, placing Californians at a serious disadvantage. Although AG Bonta is stepping up to protect Californians against a compromised Trump administration, he can only do so in federal court. We've heard from several experts that we cannot and should not rely on federal courts given this administration. His office must be given the tools to effectively act in state and in state court as well. And this isn't a hypothetical risk. We've seen what happens when a merger challenge under existing federal standard fails. When a coalition of state attorneys generals, including Californians, challenged the T-Mobile Sprint merger in federal court, they lost. Since that merger closed, the combined company has shed roughly 13,000 jobs, and I'll repeat that, has shed 13,000 jobs, about 16% of its pre-merger workforce, and wireless prices posted first sustained increase in years at the expense of Californians. That is what's at stake here. Real jobs, real household costs, left with no state-level backstop once a federal case falls short. California has lived through this exact pattern in its entertainment industry before. After Disney's $71 billion acquisition of 21st Century Fox cleared federal review, Disney pulled licensed content from rival platforms, pressured creators to forego licensing revenue, and closed Blue Sky Studios outright, eliminating both a competitor and hundreds of California jobs in one stroke. That is the same playbook now on the table with Paramount and Warner Bros. Discovery at a comparable scale. Federal data also shows that in fiscal year 2025, of the 2006 mergers reported to federal antitrust, regulators touched fewer than 1%, just 18, that resulted in enforcement action at all. The chamber is right, and I'll agree with them on this, that the vast majority of mergers raise no competitive concerns. But that's exactly why a state-level backstop is not the burdensome, deal-killing regime they describe. It would apply to a tiny fraction of transactions, the one the federal review already lets through unchallenged, 99 times out of 100. Before I continue, I also want to take a personal point of privilege to address the letter that was submitted to you this Friday with regards to AB 1776. The Chamber's letter invokes a number of amendments to AB 1776 and argues that they are a cautionary tale demonstrating the demerits of substantively departing from federal law here regarding mergers. Respectfully, all one needs to do is actually read the bill in print to know that this version of history is simply not true. The words of the bill show that California legislators are not retreating from an over century of antitrust independence from federal law and are in fact affirming California's century-old laws. First, the entirety of proposed section 16730 and proposed section 16732 are codifications and thus legislative affirmations of cases interpreting California's Independent Cartwright Act. Second, proposed section 16730 retains the following reaffirmation of California's longstanding independence from federal antitrust law, and I'll read it to you today. In subsection D, interpretations of federal antitrust laws are at most instructive when construing California's antitrust laws, as they are not modeled on a federal antitrust statutes, and that has survived to this point heading to the Senate floor. Third, and what the chamber is most likely referring to, are the amendments that were forced on us by Senate Appropriations Committee. AB 1776 was on Thursday amended at the chamber's insistence to prohibit a private right of action for single firm claims. When the Federal Sherman Act had such a right in its enactment, certainly doesn't reveal the legislature's uncritical embrace of federal law. And if we were to opine the legislature's intent from the black box that is appropriations, we might as well make the same assessments based on if the Department of Finance supports any bill over $1,000. And fourth, it is true that the commissions formally proposed Section 3 of the bill that delineated certain federal precedents and urged caution in their application was amended out. But nowhere in the legislative history is there a shred of evidence that this was because California's legislators are now broadly favoring feckless federal law or the specific federal cases the commission identified. The truth is that the section provided to be extremely confusing to legislators because it was novel and met with a historic opposition campaign that made mockery of longstanding antitrust principles like coercion and market power. Indeed, that the chamber successfully urged the legislature to depart dramatically from federal law when it comes to the rights of injured people and small businesses, beautifully underscored by the Assembly Judiciary Committee. And I quote, "In totality, much of the business community's opposition to this bill appears rooted in the fact that this bill takes aim at potential anti-competitive misconduct of some of the state's largest businesses," end quote. So now our recommendation. We strongly encourage you to adopt options 2, 3, and 4, and specifically the tried and tested appreciable risk standard. Adopting these options would enshrine these longstanding best practices in California state law and give the state the tools it needs to prevent anti-competitive acquisitions, while strengthening the enforceability and predictability of the law for small businesses, workers, and consumers across California. The commission should continue to do what it has been brilliant at doing. Call balls and strikes as it sees them, and leave the politics to the politicians. We urge you to vote to approve these recommendations. Thank you again for your continued outstanding work on this crucial study.
Thank you. Any questions for this presenter? Seeing none. Thank you. And should I mention?
Commissioner King, it's my understanding you need to step out for a while.
Yeah, I'll be leaving at 3. I'll try to rejoin the meeting, but I'm sorry, I had something come up.
Okay. Thank you. Welcome back. Oh, got to move the table up, huh? Yeah, we should go in height order.
Right. Yeah, having Eric go right after Ben was
There you go. Yep.
was instructive. So thank you, and nice to be back. My name is Dan Robbins. So just for transparency purposes, I do have a day job at the Motion Picture Association. I am in charge of global compliance, including antitrust. So it's my job to help make sure everybody knows what the laws are from Kazakhstan to Indonesia and help ensure that they're properly respected. But that's not why I'm here today. I also have a night job coming up on entering my 20th year of service in the California Commission on Uniform State Laws, and with the Uniform Law Commission, which is the national sort of parent body representing all the states. Put a lot of time in there. Was president from 2021 to 2023. ULC, just as a refresher, been around since 1892, enacted over 6,000 state laws. You might have bad memories from law school, the Uniform Commercial Code, ULC product adopted in all the states, Uniform Trade Secrets Act, working on things like child protection laws too. But I'm here today because we also have an antitrust committee, which I chair. This is the committee that drafted the Uniform Antitrust Pre-Merger Notification Act. This is something that was requested by over 20 state AGs, and I was the sponsor of the bill here. It's SB 25, which I was very excited, was signed by the governor in February. He was initially looked a little concerned, which is never good because I think he's all of our bosses. He appoints all the commissioners. But then he got a big smile on his face, and he looked up and he said, "Oh, you've got a bill supported by the AG's office, and the Cal Chamber's okay with it?" And he signed it, and we had to leave. But I think that's a good sign. I've spoken at the NAG annual meeting about this bill as well. They're interested. So I did want to talk a little bit about that and what is happening here. So the premise of the bill is the states can efficiently work together in investigating mergers, in bringing challenges, and in winning. And a lot of this work has happened. We talk a lot about Philadelphia National Bank, HHI, that's 1945, 1950, 1963. Antitrust enforcement didn't fall off a cliff in the interim between then and 2023. We just took other approaches. We passed the Hart-Scott-Rodino Act in 1976, requiring companies to produce a lot of information so we didn't have to go into these cases blind and we could make better decisions. SB 25 facilitates this joint enforcement by requiring parties to share those HSR filings with the state AG in which the law is enacted. I've only got 3 so far, but I'm planning for another 10 introductions later this year. This cooperation works. So if you look at some of the mergers that have been discussed, and another one like, Kroger Albertsons, there were 9 AGs there. They won that case. Nexstar Tegna, which is mentioned by a prior commentator, I think they started with 8 AGs. They may have more now, but they got a preliminary injunction. That's a win. That's very significant. I'm not here to talk about Paramount Warner Brothers Discovery for sure. When one of your day job members puts itself up for sale and 3 others bid on it, it's something staying far away from. But there's 12 AGs there, and they got a TRO. They're going to trial in March. This is working. I don't. Prior commentators have mentioned this is a sign of failure. I think this is a sign of success. Now, why this relates to what we're doing here is you need, if the AGs are working together and have common facts and common law, it's easy to divide up all the tasks and to bring these actions together. SB 25 is an attempt to get them all to have the common facts in an easier setting. I was worked at night at the AG's office way back in law school for a little bit on the Lucky Alpha Beta merger, which, the state also won that one, unanimous decision in the United States Supreme Court. But, that case took years because it took a lot of time to get the extra material. That case also was an example of the FTC approving a merger that California disagreed with and took it up and confronted the arguments that Kathleen made earlier, and the Supreme Court ruled unanimously in the state's favor. So courts can see through that. But what I'm worried about here is if we're not operating with common law, if we take the Clayton Act and let's say we do appreciable risk or we make some other changes to it, how's that going to work? These other states, I don't think they can't stroll, maybe they can, or maybe they can't stroll into our courts and bring these enforcement actions. But if we've got a different set of laws, then, what's going to happen there? Is it going to be that other states who are today cooperative are instead going to sit back and free ride on California and its taxpayers to do the heavy lifting? To me, that would be a loss. We've got to be sensitive to these cost issues. You probably saw the Department of Finance was mentioned earlier. It did oppose AB 1776 for cost reasons. That department is part of the executive branch, so that's something we have to look at. Like if what we do here causes California and California taxpayers to take up a lot of the burdens, and getting a thank you note from Ken Paxton or even Tish James is not going to be terribly helpful. Like we need to, my view is we need to find a way to work together with the other states, share the costs because we share the benefits. And so, I hope that, when you look at all this stuff, you bear that in mind and try to find a solution that, minimizes the divergence from current federal law. And I'd also, encourage you to think about, yeah, there's some federal cases that, in my view, weren't decided right, but there's an awful lot that were. And so you have to be careful when you just push those aside. Like there's a famous, the Brunswick case by Justice Thurgood Marshall, writing for a unanimous Supreme Court, is a merger case about who can bring a challenge. And I think it's a very thoughtful case. Like we can't just, push all that stuff aside, because that's the stuff the other states have as part of their arsenal and they have to rely on. So I appreciate your time and patience, and just if you could, as you're thinking through what to do, try to, do it in a way that's sort of complementary to the efforts of SB 25 and other things that the Uniform Law Commission is trying to accomplish. So glad to answer any questions. I appreciate your time.
Do we have questions for Mr. Robbins? Seeing none, thank you, as
Very good.
always.
Thank you.
Appreciate it. I think that's all of the in-person. How many online presenters do we have? 7? Okay. Why don't we go ahead and start with the first one?
Lee Hepner.
Welcome back.
Hello, and thank you so much, Commissioners. Lee Hepner. I am Senior Legal Counsel at the American Economic Liberties Project. Thank you for taking this issue up today. The story of iRobot is actually is fascinating and worth kind of looking into. There's a good history of this that was written by Matt Stoller called How Wall Street Destroyed Roomba and Blamed Lina Khan. And it really is the story about how Roomba transformed from its early days in the early 90s as a spinoff of MIT from a company that was a robotics company, that was an engineering company that picked up DARPA contracts in the late 1990s. And, by the early 2010s, investors led by Goldman Sachs, saw that it was a consumer facing robotics company, slashed its research budgets, invested everything in the Roomba, which I have and is about to turn on right behind me. But really kind of lost its prowess that way. I mean, it was a company that was really lost to financialization. And by the time 2022 rolled around and Amazon thought to acquire it, it was a financial decision born out of a reluctance and an abandonment of their decades of work on robotics. So I encourage folks to read that story. I just on the text before you, the conversation around substantially
Lee,
less than competent.
Can you speak up just a little bit?
Oh, yes. Yep, I can certainly do that. Is this better?
I think so.
Okay, I will continue until I'm told otherwise.
Okay.
The text before you on the question of the language regarding the role of the word substantially. There's a great paper on this by antitrust practitioners and scholars Basil Mischerbosch and Daniel Hanley that talks about how substantially, yes, was supposed to modify the probability of a transaction lessening competition, and really kind of outlining how courts have mistaken that word substantially as measuring the extent to which something must lessen competition. Courts do get this wrong. In the Federal Trade Commission's challenge to the merger of Microsoft and Activision, the court wrongly interpreted the word substantially as modifying the extent to which competition is lessened, not the likelihood of a lessening of competition. And since that court blessed that merger, Microsoft has laid off 1,900 Activision employees, another 650 employees from Microsoft's gaming division. I have no problem with this commission recommending adhering to the strict language of the Federal Clayton Act, which is maybe substantially to lessen competition. The one recommendation I have is that the commission's recommendation not be internally inconsistent. And in subsection E, I think the text is used in the inverse way, where may substantially refers to the extent to which competition is lessened. And so that could create some confusion if this were to become law. All of the options before this commission are consistent with federal law. Every single one of these options before this commission, including the alternative statements, are consistent with federal law. Now, this is distinct from the commission's work on single firm conduct, where it incorporated, among other things, a single firm restraint of trade provision that I think, while many of us argue has extensive representation in the law, does not exist in the literal text of the federal anti-monopoly law. That's different here. So the Philadelphia National Bank, that's among the core prevailing Supreme Court interpretations of federal case law. Tend to create a monopoly is the literal text of the Federal Clayton Act. HHI presumptions are thoroughly represented in federal case law and have been invoked as recently as in litigation against the Paramount Warner Brothers merger. The merger guidelines contain 85 citations to cases interpreting federal antitrust law. And you have a letter in your packet from one of the authors of those guidelines at the Justice Department describing how the merger guidelines were designed to reinforce the text of federal antitrust law, which protects, quote unquote, competition. The Trump administration now has rolled back quite a bit of work performed under the Biden administration, but it has left those guidelines intact. The appreciable risk standard, reasonable probability standard are similarly grounded in federal interpretations of the Clayton Act. You've heard a lot about the Brown shoe case, which uses the incipiency language, which I would be happy as well if that alternative language made it in here, but are embodied, I think adequately by appreciable risk and reasonable probability. If this commission recommends every option before it today, it should be accompanied with a very clear statement that this is consistent with existing federal case law. As such, it apprehends further weakening of that law. Another way of framing the task before the commission, as I see it and have been following along for some years, why would a plaintiff ever choose California law if it enumerates the same exact standards as federal law? The answer is that there is a robust effort by big business, by hedge funds, by Wall Street, by private equity, dating back 50 years to further weaken federal law. And we have seen that in practice. That is what this project is responding to. And we are seeing the abdication of federal antitrust law under the Trump administration. The federal administration at this point is a wanton participant in the weakening of federal law. You see this with the Nexstar-Tegna merger, the HPE-Juniper merger, the Compass Anywhere merger, the Paramount Warner Brothers merger, all mergers worth tens of billions of dollars waved through by this federal administration, causing Gail Slater, the Republican head of the antitrust division under Trump, until she was ousted from her post around the same time the Trump DOJ abandoned the Live Nation case, to author an article called, quote, "The Feds Don't Have an Antitrust Monopoly." That is what I think the commission stands for with this project. And the commission can articulate that it is codifying prevailing interpretations of federal law. I think it should do so in its purpose statement. And codifying these standards responds to a federal judiciary that is increasingly captured by by the corporate defense bar, and a current federal administration that appears bent on weakening competitive markets. Finally, this commission must be mindful of how opposition is moving the goalposts. No longer are they superficially concerned with California codifying an expansion of federal law, but they are opposed to any codification whatsoever, even one that matches existing federal law. That is a profound distinction and a real change in their approach from what we've seen with the single firm conduct effort embodied in AB 1776. California Life Sciences says that this, quote, poses unique risks for life sciences companies. They should be asked by this commission why that risk doesn't exist under current federal law. What specifically about codifying federal legal standards is a, quote, existential threat to their business model. The Chamber of Commerce says that these proposals reflect, quote, dramatically different policy positions, quote, than under federal law. The Chamber should be asked how they think this version differs from federal law. They do not say. Mr. Ensign mentions the de minimis language, which has a lot of credence under Brown shoe, under the incipiency standard. He points to a multiplicity of standards otherwise, all of which exist under federal law. The guidelines only cite federal law. How do they think the guidelines are at odds with federal law? These are important questions, and I'm very interested in knowing what these entities are for, what the chamber is for, what California Life Sciences is for, because all I have ever heard is what they are against. They have never offered a single proposal, either on the single firm conduct proposal or this proposal today, for what they will support. And to Mr. Robbins' admonition that we should find consensus positions, that we should find something that all of us can rally around, this should be it. As the commission considers adopting a proposal that codifies prevailing federal antitrust standards, I think the questions that I've presented are even more pronounced, and respectfully hope that the commission directs those questions at the opposition. Thank you very much.
Thank you, Mr. Hepner. Any questions? There appear to be none, so thank you very much. Next presenter.
Indernath Sackerman.
Okay, welcome.
Hi, everyone. Can everyone hear me?
Yeah, go ahead.
Awesome. Well, thank you all so much. My name is Kedarnath Sankararaman. I'm Policy Counsel with the Association for Competitive Technology, ACT. We're a global trade association for small and medium tech companies. We previously written in comments to the commission and also provided verbal comments in the commission's March meeting, and my brief comments here today will be building up on those. Firstly, at the outset, I want to say that we at ACT, we strongly support effective merger enforcement where a transaction threatens competition or consumers. However, before California creates a new substantive merger standard, we believe the commission should identify the specific enforcement problem that requires a separate state standard. We don't think that problem has been identified. California is already an active merger enforcer, and the state AG can challenge anti-competitive transactions under federal antitrust law. As has been mentioned by other commenters today, California also has laws requiring advanced notification of certain mergers, and beginning next year, certain federal HSR filers with a meaningful connection with California would also have to disclose their filings to the California State Attorney General. California, therefore, has substantial tools to identify, investigate, and challenge anti-competitive mergers. A California-specific substantive standard would add another layer of compliance and regulations for businesses like ACT members who operate nationally and globally to comply with. We believe such a departure should be supported by clearly demonstrated enforcement gap and need. The additional uncertainty would fall particularly hard on startups and small businesses. For our members, acquisition is often a critical pathway for them to scale and exit, and even the prospect of an acquisition can strengthen a startup's ability to raise capital. Making exits more difficult can make their entry more difficult as well. Acquisitions, crucially, also give ACT members and small firms access to capital, technical expertise, infrastructure, compute, and distribution that they need to compete. This is particularly true recently in the fast-moving AI markets. We're also particularly concerned about codifying structural presumptions into California law. The proposed framework would codify the United States v. Philadelphia National Bank Standard, which is a 1963 horizontal bank merger decided before modern HSR review system was put into place. Today, reportable transactions can be examined before closing, and enforcement agencies can obtain extensive transaction-specific information. Merger analysis is inherently fact-specific. Competitive effects depend on a particular market, the relationship between firms, competitive constraints, and the effects of the transaction. Codifying a presumption drawn from decades-old bank merger case risks giving that formulation disproportionate weight across industries and markets with very different competitive dynamics, particularly in fast-moving technology markets today. We have similar concerns and even more concerns with hard-coding numerical thresholds and presumptions based on those thresholds for the 2023 merger guidelines. HSI and market share can provide information about concentration, but their significance depends heavily on the facts and on how the relevant market is defined. Once a statutory presumption is triggered, the burden shifts to the parties and bringing additional cost, delay, and litigation risk that can influence whether a transaction is pursued at all. The proposed rebuttal standard particularly compounds that concern. As drafted, the parties would have to demonstrate either no likely anti-competitive effects or that those effects are de minimis and clearly outweighed by cognizable pro-competitive benefits in the same relevant market. Limiting cognizable benefits to the same relevant market can therefore make the treatment of genuine efficiencies depend heavily on how narrowly that market is defined. Requiring anti-competitive effects to be de minimis before those benefits can rebut the presumption makes the standard narrower still. Merger analysis should preserve flexibility to consider the full competitive effects of a transaction. Finally, we are also particularly opposed to the appreciable risk standard. The proposed statutory formulation, an appreciable risk of lessening competition more than a de minimis amount, would create a new operative standard without a developed body of case law interpreting that language. If the Commission believes that may requires clarification, we believe that the reasonable probability formulation is substantially preferable to the appreciable risk standard. It addresses concerns about requiring too much certainty while remaining grounded in familiar merger doctrine. We would encourage the Commission to make the balance more explicit, however. Certainty is unnecessary, but the mere possibility is also insufficient. For these reasons, we at ACT urge the Commission to preserve a predictable, evidence-based, and fact-specific approach to merger enforcement and avoid new substantive standards and presumptions that could deter pro-competitive investment and acquisition. Thanks so much for your time, and I'm happy to answer any questions.
Thank you. Any questions for this presenter? Seeing none, thank you very much. Who's next?
Bryn O'Neill.
Ms.
Hello.
O'Neill? Welcome.
Thank you, Chair and Commissioners. I'm Bryn O'Neill, a policy specialist with the California Nurses Association, a labor union representing over 100,000 registered nurses across California. As we've outlined in coalition letters, we support option 4 with revisions, combining key elements of options 2 and 3 with the crucial appreciable risk standard. So our letters outline why these options are tested, practical, and legally sound, as did Lee Hepner. Today, I want to talk more about why these changes matter to nurses. The state of the healthcare industry shows that current law is not getting the job done. Extreme consolidation in healthcare hurts nurses and patients. When a few corporations control hospitals, clinics, pharmaceuticals, and health insurers, they dictate the terms of the market, including wages, working conditions, prices, and quality of care. Too often, nurses are faced with a choice between just a few possible employers, each with outsized power over the labor market. These mega corporations use their resources to union bust and to slash staffing. And too many nurses leave the bedside instead of working under the conditions these corporations create. Codifications, specifically of the 2023 Federal Merger Guidelines as persuasive authority, could help enforcers and courts understand and prevent labor market harms. Decades of weak interpretation of antitrust laws have let corporations both complete some large mergers and roll up huge percentages of specific healthcare markets through a series of small transactions, and then use that power to increase prices on life-saving care. The appreciable risk standard and the list of rebuttable presumptions laid out in option 4 could help combat this trend. We would also urge you to add a presumption against mergers if a company has a pattern of serial acquisitions. Healthcare corporations also use acquisitions to engage in medical redlining. They buy up hospitals in neighboring areas and then close hospitals or units in areas with a high percentage of Medi-Cal patients to consolidate services at facilities they also own in more affluent, profitable areas. We've seen that California enforcement agencies are ready and willing to tackle healthcare consolidation. The Attorney General's office has used existing powers over certain nonprofit healthcare sales to put conditions on mergers that effectively protect workers and patients from the worst harms of the consolidation. But existing law isn't enough to cover all healthcare entities, let alone the rest of the economy, and prevent the sort of giant conglomerations that we see today. We need so much more, and these recommendations are a crucial move toward positive change. Thank you so much for your time and all your work.
Thank you, Ms. O'Neill. Any questions for this presenter? Seeing none, thank you. Next up,
Amy Hines Shake.
okay.
Hello, Honorable Chair and members. My name is Amy Heinscheich with Wildcat Consulting, speaking on behalf of the United Domestic Workers, AFSCME Local 3930, and our 250,000 IHSS and home health supportive services and family child care workers across the state of California. For the past several years, UDW joined with the Anti-Monopoly Coalition, which includes labor and consumer advocates, business leaders, and antitrust experts, to follow along with this study. As a member of the coalition, we stand in strong support of options 2, 3, and 4, and laud the incredible work of the staff, of course, specifically in support of the appreciable risk standards. Our workers are the backbone of California's care economy. Our members help seniors remain in their homes with dignity, support people with disabilities, and educate children so parents can work knowing their kids are safe, supported, and nurtured. Despite the essential care our workers provide, which contributes to California being the 4th largest economy in the world, everyday Californians like our providers are struggling with the impacts of the concentration crisis and the increasing levels of inequality across the country. As a union primarily made up of people of color, we know that the economic effects of concentrated corporate power have disproportionate consequences for workers and communities of color, exacerbating inequalities caused by racial exclusion and other forms of extraordinary systemic discrimination. Mergers have replaced organic growth through positive innovation that benefits consumers and workers, instead led with the pattern of acquisitions that have resulted in greater shareholder profits at the expense of layoffs, decreased union power to negotiate better wages and working conditions, which are even higher prices, which increase prices and lower working conditions, and have higher prices with fewer opportunities for small business. Merger reform fills a severe gap in California. We do not currently have a law that explicitly allows for mergers to be challenged in our state courts, and that is why we are strongly in favor of options 2, 3, and 4. At a minimum, Californians deserve the best practices available to be codified so illegal mergers cannot happen. With respect to your work regarding single firm conduct, thank you deeply for that incredible work. We are amazingly proud to be co-sponsors of the incredible bill, AB 1776, and its very pro-working class provisions. We can't wait to get it passed by the legislature and signed by the governor of this great state, and we hope you attend the signing ceremony with us because it's based on your wonderful, wonderful work. Thanks so much to the staff. We really appreciate you, and thanks for your time.
Thank you, Amy. Any questions for this presenter? Seeing none, thank you so much. Next.
Donnie Tedeschi.
Good afternoon, Chairperson Simpson and Commissioners. My name is Donnie Tedeschi. I am the statewide organizing director of Rise Economy, and I'm representing my organization as well as our member alliance of over 300 nonprofit organizations throughout the state. These organizations are dedicated to combating the legacy of redlining in communities of color by holding banks accountable for their role in creating community-centered economies. Our members include affordable housing developers and providers, CDFIs, small business and micro entrepreneur technical assistance providers, financial coaches and asset builders, housing counselors, tribal groups, and tenants and labor rights advocates. For the past several years, I have followed along with the CLRC's study and joined the Anti-Monopoly Coalition, which includes labor and consumer advocates, business leaders, and antitrust experts. We stand in strong support of options 2, 3, and 4, and specifically in support of the appreciable risk standard, which is a best practice firmly rooted in existing federal law. Rise Economy's entry point into this issue comes from our work combating the troubling consolidation in the financial services industry and its disproportionate impact on people and communities of color. This is an area of corporate consolidation our state is currently ill-equipped to address. Today, banks are merging at the fastest pace in 35 years, enabled by merger-friendly federal regulators and weak state and federal laws. While the trend is accelerating, it's not new. Consolidating market power and growth through mergers and acquisitions is embedded in the financial services industry's ethos. Through decades of mergers and acquisitions, the top four banks now hold about 30% of the nation's $18 trillion in deposits, and the top 10 hold a bit over 44%. Even credit unions are not exempt from this troubling practice. Just 10 years ago, credit unions acquired a handful of small banks annually, but they're now buying institutions worth hundreds of millions of dollars and eliminating both tax liabilities and Community Reinvestment Act motivated loans and investments, since credit unions are not subject to the federal CRA. Credit unions are also overwhelmingly targeting community banks that rural and native and tribal communities disproportionately rely on for banking services and access to capital. This is further exacerbating the disparities in credit and capital access in these regions and for these communities. Bank mergers and unfettered consolidation causes lasting harm, and yet the federal review process remains tilted towards approval and lacks safeguards to protect consumers and communities. Unfortunately, the state review process is functionally absent. The vast majority of bank mergers are approved both at federal and state levels, even when there's significant concerns from community groups about the negative impacts they'll have. Mergers and this level of consolidation have resulted in communities, particularly communities of color and low-income communities, suffering from lost jobs and reduced hours and working conditions for community development and frontline bank branch staff, closed branches and decreased access to financial services, decreased reinvestment activity, reduced access to credit for small businesses. This is reflected in the data and direct testimonies from our coalition members that are CDFIs and small business technical assistance providers. There are higher costs and fees for bank customers and consumers. These mergers without adequate scrutiny can exacerbate climate change concerns and create greater climate-related financial risks to the financial system. Compounding this crisis is the Trump administration's abandoning of its duty to uphold the rule of law and reversing hard-fought policies and regulations that have guided oversight of financial institutions for decades. Some critical pieces here are the stalled implementation and severe weakening of hard-fought efforts at eliminating lending discrimination in small business lending through the Section 10.7 on the Dodd-Frank Act, and repealed efforts to modernize bank supervision community reinvestment guidelines, including rescinding the updates, the 2023 CRA rule updates. And now, even more troubling, the Trump administration is proposing a new set of CRA rules that will have significant negative impacts on California, including significantly reducing the number of banks subject to key lending and investment examinations, small business lending discrimination protections, and broadening definitions of reinvestment activities to include projects that may not specifically impact low-income communities. These are just among other issues. These all have the effect of weakening CRA examinations, and CRA performance is a statutory factor in bank merger approvals. That means weaker exams equals less public leverage as this industry keeps consolidating. Elsewhere, there are repealed efforts to cap predatory junk and overdraft fees, the crippling of the CFPB, the limiting or entirely elimination of core funding streams for CDFIs, small business, SBA, women business centers, minority business development agencies, and many other critical components of California's community and economic development ecosystem. Rise Economy, our members and allies have long called for state-level policies that would, among other things, equip the FPI and state attorneys general with more authority to scrutinize and even reject mergers in cases where communities would be worse off, respond to the ever-changing financial services landscape, and properly regulate and extend reinvestment obligations to financial institutions like fintech companies, like credit unions, like non-bank mortgage companies, all who are not covered under the federal CRA. And lastly, further protect stability of the California financial system from federal attacks and inaction. We're very concerned about bank consolidation, and we've been ringing the alarm for many years, decades now. and it is accelerating at a pace that the state is not equipped to address with the current set of laws. So we strongly urge the commission to take a look at this particular issue. And if you have any questions about how the state can respond to this kind of consolidation in the financial services industry, I'm happy to answer any questions. Thank you for your time.
Okay, thank you. Any questions for this presenter? Seeing none, thank you very much. I understand we have 5 more. If they could, we want to make sure we have time for everybody to, make their presentation, and then for the commission to kind of figure out where we're going to go from here. So if they keep it as brief as they can. Thank you. Next.
Peter Leroy Mignot.
Welcome.
Hello, Commissioners. This is Peter Leroy Munoz, SVP and General Counsel. I'm speaking on behalf of the Bay Area Council, a business and civic association representing nearly 400 member companies throughout California's innovation ecosystem and broader economy. While we strongly support robust, fair competition, we caution against proposed statutory changes that risk inadvertently harming California's broader economy and its innovation ecosystem. For this reason, we encourage you to maintain alignment with the traditional federal Clayton Act standard via option 1. California's global economic leadership relies on a dynamic cycle of enterprise where early stage startups scale using platforms built by established firms. Mergers and acquisitions provide an essential exit strategy for founders and investors. Undermining these transactions chills venture capital, dampens entrepreneurship, and threatens the nearly 1.5 million technology-supported jobs in our state. Decoupling California's merger standards from long-standing federal precedent creates a confusing, two-tiered regulatory environment. Transactions cleared by federal authorities could face conflicting state standards, generating legal friction and discouraging normal business expansion across state lines. Modern corporate acquisitions frequently enable companies to offer integrated services and deliver products at competitive prices. Expanding state liability thresholds beyond traditional competitive harm risks restricting these efficiencies, ultimately reducing choices and raising costs for California consumers. Existing federal laws in the Cartwright Act already empower state and federal enforcers to block genuinely anti-competitive deals. We urge the Commission to preserve our thriving innovation economy by maintaining harmony with established antitrust standards. Thank you.
Thank you very much. Any questions for this presenter? Seeing none. Okay. And who's up next?
Jin Suh.
Hi, thank you to the Commission and staff for your dedication and hard work on the critical topic of antitrust reform in our state. My name is Jennifer Suh, and I'm speaking on behalf of the Writers Guild of America West, a labor union that represents more than 11,000 writers of movies, television, and streaming series in California's vital entertainment industry. I'm pleased to address the Commission today and reaffirm our statement that we shared before the Commission in May, as well as in a comment letter that we submitted last week. Significant strengthening of state antitrust law is urgently needed for the media and entertainment industry in California. Today, California lacks explicit statutory grounding in state law to challenge mergers. Enhancing the state's antitrust law would enable state enforcers to try antitrust cases in state court and allow California judges to develop stronger legal standards. To that end, we encourage the Commission to adopt options 2, 3, and 4 in the staff memo on merger provisions. The entertainment industry has seen waves of horizontal and vertical integration over the decades, resulting in what we see today: a heavily concentrated industry dominated by a handful of powerful firms that decide how much content is made, how Writers Guild members and other industry workers get paid, and what viewers are able to watch. To understand the harms generated by media consolidation, we don't have to look much further than the proposed acquisition of Warner Bros. Discovery by Paramount Skydance. Through this ongoing merger, Californians have seen that we cannot rely solely on federal enforcers for protection from the harms of corporate consolidation. In June, we saw the Department of Justice reportedly rush approval of this merger over the objections of career staff. A coalition of 12 states, led by our Attorney General, Rob Bonta, were forced to step up and sue to block the merger to protect Californians. The Writers Guild of America, alongside the states, have sued to block the merger to protect our members from the harms of anti-competitive conduct. This merger would be catastrophic for our industry, particularly in California. If Warner Brothers merges with Paramount, the merged company would become the largest employer of our members. Both companies are industry giants, and the loss of direct head-to-head competition will harm writers and eliminate jobs across the industry, with pronounced impacts in our state. A combined Warner Brothers and Paramount would create a media behemoth with tremendous leverage to reduce content, raise prices, increase control of production, suppress worker compensation, and worsen working conditions. Furthermore, a merger would fundamentally threaten the diversity of voices we see represented in American culture by increasing the power of a small number of gatekeepers to decide whose stories get told. And with fewer gatekeepers, that consolidated media power can turn into political power, which threatens free speech and creative expression and ultimately hurts our democracy. Stronger state antitrust law would bolster our efforts to challenge harmful mergers like the Warner-Paramount merger. A law that integrates enhanced merger provisions proposed by options 2, 3, and 4 of the CLRC Staff Memorandum 2026-21 would empower us with more effective tools to protect Californians against higher prices, lower wages, less diverse content, and limits to creative innovation. The Writers Guild supports the revival of structural presumption standards, the codification of key sections of the 2023 merger guidelines, and the adoption of an appreciable risk standard to lower the burden of proof for merger challenges in California. If the Commission doesn't recommend an appreciable risk standard, we strongly urge the codification of a reasonable probability standard to make clear the Commission's intent to stop the trend of consolidation before it results in entrenched market power. In closing, we thank the Commissioners and CLRC staff for your attention to this critical review of antitrust law in California, and we urge you to take advantage of this timely opportunity to clarify the long overdue reform California needs in M&A legislation. We need to modernize competition policy to apply to today's economy, to protect workers from lower wages, to protect consumers from higher prices, and to protect access to diverse and creative content in the media by ensuring healthy competition in the media and entertainment industry. We urge the Commission to take these imperative steps to support a vibrant economy for all Californians. We look forward to engaging further on this topic, and thank you for your time.
Thank you very much. Let's see, are there any questions for Ms. Sun? Seeing none, thank you. Next up.
Teresa Ramirez.
Hello
Welcome.
and good afternoon, Chair Simpson, Commissioners, and staff. My name is Yarisa Ramirez, and I am the Associate Director of the Consumer Federation of California, a nonprofit that since the 1960s has been advocating for the rights and protections of all consumers. I want to begin by thanking the Commission and its staff for all the work that you have done and that you continue to do on this very important issue. On behalf of CFC, I am here to express our support for options 2, 3, and 4, as well as our preference for an appreciable risk standard. As you have heard from many stakeholders today and from our coalition comment letter submitted last week, consolidation is occurring across virtually every sector of our economy. This increasing concentration of market power harms consumers, small businesses, and workers alike. CFC believes that protecting these groups requires proactive action now and not just after the harm has taken place. For many years, CFC has worked tirelessly to address the harms resulting from the Live Nation Ticketmaster merger. We do not want to see those harms replicated across other sectors of the economy. And for that reason and many more, we urge the adoption of an appreciable risk standard and options 2, 3, and 4. Again, thank you for your time and for your continued work on this issue. We are always happy to serve and assist the commission in any way possible. Thank you for your time.
Thank you, Ms. Ramirez. Any questions for her? Seeing none. 2 more presenters online. Next up.
Suleiman Kenyatta.
Good afternoon, Chair Simpson, commissioners, and staff. My name is Suli Kenyatta, and I'm speaking on behalf of Small Business Majority. Small Business Majority is a national small business organization that advocates for policies that support a thriving and equitable economy for entrepreneurs. We work directly with small business owners and business serving organizations across California to elevate their experiences and ensure their perspectives are represented in policy discussions. As a reminder, micro businesses and very small firms make up the backbone of California's economy, anchoring local commercial corridors, creating jobs, and helping keep wealth circulating within communities. Small Business Majority has been involved in this process for the past several years because we continue to hear directly from small businesses feeling the impact of corporate consolidation across industries. For small businesses, mergers and acquisitions are not abstract legal or economic issues. They can determine whether an independent business has access to customers, contracts, suppliers, financing, and a fair opportunity to compete. When markets become more concentrated, small businesses can face fewer buyers, higher costs, and more restrictive contract terms, and less bargaining power. That is why the merger framework and legal standards before you matter so much. California has to have the legal tools necessary to address competition issues in our own state. Small businesses should not have to rely solely on federal courts or federal enforcement to address anti-competitive conduct that is affecting their ability to compete here in California. A key question for us is, how can a small business realistically address harm in a California state court if our state laws do not provide the appropriate standards and tools to challenge anti-competitive mergers? We have heard from small business owners in sectors like entertainment who have seen consolidation concentrate production, distribution, and contracting opportunities among fewer large companies. Others have described being forced into costly third-party systems or facing increasingly difficult terms simply to do business with larger corporations. These are examples of how market concentration can affect an entire small business ecosystem, even when those businesses are not parties to the merger itself. Small Business Majority supports options 2, 3, and 4 and supports codifying this language into California law so that the state has clearer, more effective tools to review potentially harmful mergers and address competitive harm. Strong merger guidelines are fundamentally about preserving competition and opportunity. California small businesses need a marketplace where there are multiple buyers, multiple suppliers, and genuine opportunities to compete, not one where economic power is increasingly concentrated in a small number of corporations. Thank you, commissioners, for your time and for considering a framework that gives California meaningful legal tools to protect competition and address the impacts of corporate consolidation on small businesses in our state. Thank you again.
Thank you. Any questions for this presenter? Seeing none. And next up.
Gilbert Lara.
Okay.
Good afternoon, Chair and Commissioners. Gilbert Lara here on behalf of Biocom, the world's largest life sciences association. On Memo 2026-29, we urge the Commission not to codify the HHI metrics in statute and to reject the appreciable risk standard. Life science is California's second largest industry, with over 400,000 workers and $394 billion in economic output. And the evidence shows that mergers and acquisitions drive that success. A peer-reviewed Cornerstone research study of more than 33,000 drug projects found that drugs undergoing M&A are nearly twice as likely to reach patients. And for novel drugs meeting an unmet medical need, more than 3 times as likely to launch. M&A isn't a threat to innovation, it's a primary driver. And our concern is fit. The HHI and market share metrics are built for firms with products and revenue. A development stage biotech has neither. It earns nothing until the FDA approves its therapy or product. And in our sector, a market may have only 1 or 2 treatments, not from anti-competitive conduct, but but because that's how targeted science and FDA approval process works. Codifying these thresholds into statute would presume harm in exactly the deals that bring new therapies to patients. We'd add that the appreciable risk standard would be new as a statutory test, with little case law to guide how courts apply it, adding uncertainty that falls hardest on the early stage companies least able to absorb it. California's patients, workers, and researchers deserve a merger standard that reflects how this industry actually works. We urge you to keep these additions out of the recommendation. Thank you.
Thank you. Any questions for this presenter? Seeing none. Anybody else? That's it. Okay. Thanks to everybody, both online and in person, for your comments, providing important information for the commission's consideration. How do you want to go forward from here? Commissioner Correa? I saw you hit your speaker. I'm very knowledgeable about speakers.
I would direct the commission's attention to page 18 of the memo. 26-29.
18 of the memo?
Right.
Okay.
The italicized portion beginning reasonable probability.
Mm-hmm.
I suggested to the commission that this is the direction that we should go. The indented paragraph, new subdivision X. If I were king and I had a couple of days, I might wordsmith this a little bit, get another 5% out of it. But the idea is there. And I think the idea that we have been reaching for, the solution is this this report from the legislative history that the staff found to the 1950 amendment to the Clayton Act. I think this is the solution. And here's why. What we're looking for here is a standard. And along the way, we've looked, in this context and in others in this study at things like the European standard, market share, the HHI test that's in this memo. And I and a few of the other commissioners have been uncomfortable with those because they impose somewhat arbitrary markers. And I think what we've been looking for, the reason we were uncomfortable with those is because they're bright line rules. And what this question calls for is a standard. And reasonable probability is both the standard I think we've been looking for, and it's the formulation of that standard that we've been looking for. Because essentially what we need here is something that sets the burden of proof. And this to me is the right solution for a few reasons. One is I think it's the right concept that we've been looking for. Two is it's the right phrasing for that concept. And three, it has the benefit of being what Congress intended in the first place anyway. So these factors to me answer all questions and concerns. So if the question is uncertainty, for example, I think we could dismiss that because not only is this something that's been in the law since 1950, it's something that the courts in California and their federal colleagues are very familiar with. I think this is an answer because it doesn't require us to create new language, so we avoid the uncertainty problem there. And I think that it sets the right standard with the right language. And by that, I mean, this is a term of art with which any lawyer, any judge, anywhere in the country, state or federal, Alabama or California, will be familiar with. This will ring familiar to them. Every lawyer is familiar with reasonable suspicion, probable cause, beyond a reasonable doubt, clear and convincing evidence. Terms of art like this are intimately familiar to anyone who works with the law. And something that is a reasonable probability, it's an objective standard. I looked it up.
Mhm.
Black's Law Dictionary. The analog here, I think, would be probable cause if we were in law enforcement context. Probable cause to issue a warrant or to indict somebody. Probable cause test then is an objective one. For there to be probable cause, the facts must be such as would warrant a belief by a reasonable man. Every law student in their first day in torts class learns about the average reasonable person. That's what this standard embodies. It's not clear and convincing evidence. It's not more likely than not. It's an objective test that incorporates things like market share. It incorporates things like HHI metrics. Those are evidence that a person can use to argue one way or the other. My merger should be allowed to happen because I have an HHI score below 1800, or this merger should be barred because it's 47.5% of the market share, whatever. Those are things that you can argue make the standard met or not, that make it reasonably probable that this merger is likely to have anti-competitive effects, right? Whatever. So I think all along, my discomfort with the objective standards has been me looking for an objective standard like this one. And I think that not only is this something that I would be very comfortable with, I think this is something that is already embedded in the law. And it's the right phrasing for it. It doesn't require us to reinvent the wheel. If the staff hadn't found this bit of legislative history, I think we would be compelled to go in the direction of appreciable risk. But to me, this makes that unnecessary. Why would we come up with this new formulation when folks at Cal Chamber will very legitimately be able to say, no one knows what that means. It's a new thing under the sun. Mm-hmm. Why would we do that when we have this that's already in the law? We should use this.
So to clarify, and I have kind of a similar view, this would be a subdivision attached to the language that starts on page 10, the basic merger framework language. It has A, B, and C on page 10, D and E on page 11, and that section on reasonable probability would be attached to that section.
I'd be fine with that. It's also something we could build into one of the existing paragraphs. I don't have a strong position on that.
Yeah, I think that's, we'll tinker with things as we're drafting.
Yeah.
But I think that the idea is that it would be a subdivision added to the basic merger framework. Everything we presented was intended to build on that.
Yeah, I spent some time this morning with a piece of scratch paper trying to wordsmith the text in proposed new subdivision X, and I came up with a couple of alternates, but having it in its own section, I'm not married to that. It could be its own section, or it could be built in somewhere else. Whatever my colleagues feel is best.
What I think with any tentative recommendation, if that's where we're headed, what the staff needs to know is like, are you buying into the concept? And we can continue to look at the language and see if it needs to be revised, and maybe even consult with the Legislative Council.
Yeah. So I'm curious what my colleagues think, but I think the reasonable probability resolves much of the discomfort that we've had and much of the uncertainty that we've had along the way. I think it's the solution.
Let me
ask a question. Is your proposal incorporating the HHI formula or not?
Not.
Okay.
Not. I mean, what's going to happen, Victor, is if we do as I suggest, someone will walk into court with an HHI calculation. Probably both sides will walk in with that, and they'll probably be different, and they'll argue it out.
Right.
And it's a question of what weight the court gives to that evidence in determining reasonable probability.
And I suspect that's going to vary depending on the kind of market
Right.
that can be in the first place.
Right. Yeah. So I think that there still will be fights over market definition. I think that's inevitable.
Sure.
But that will be both less important and less outcome determinative, and it won't necessarily occur in every case.
Other people have comments about that, thoughts about that?
Chair, I need not speak because Commissioner Carrillo summarized my position. I agree with what he articulated with regard to reasonable probability.
Okay. Maria, any thoughts?
Yeah, I'm on board too. I think it was really helpful to explain it that way. I'm wondering if we should add some case citations or references to the legislative history just to bolster that.
So certainly in the comments, we can do that, but we can also look at the language. You're suggesting that it should be in the statute?
I am, just because I was looking at some of the revisions to AB 1776 and I noted that they did that. I can't remember now what section it is, but they added like 5 case citations. So I'm not, married to that, but
We can certainly look at it, yeah.
And the other thing I was going to ask about was, what do people think about that would be an option that deals with be the basic merger framework. It would not have the option 3 HHI stuff. It would include the paragraph that Commissioner Carrillo mentioned. What do people think about the purpose statement? Should we include
page you
that?
on?
Not include it? Page 19? 19 and top of 20? This is the kind of why we're doing this in the first place stuff. Is that something we should include in statute?
We already voted on that, don't we?
Yeah, didn't we already do this?
I don't
I
remember.
think,
Recall.
I don't think there was a vote. My recollection off the top of my head is that there was consensus
Yeah.
that there should be the purpose
Okay, yeah,
statement.
just
Victor, correct me if I'm wrong. We all agreed on this, right?
Yeah,
Yes.
I think we all found it very helpful to set the context.
yeah, okay, yeah. I know what
But,
you-
but you're right, it may not have been a formal vote.
Oh, I'm still on board with it. Would you like a motion?
So I'm trying to think, because I had divided it up piece by piece, but it sounds like there could be a more efficient motion that would be to direct staff to draft a tentative recommendation that includes the basic merger framework, then jumps to the
Section X.
Section X on page 18, the reasonable probability, and then the purpose statement. Is that everything? Everybody's in agreement? So if somebody wants
Yes.
to make a motion.
Sharon, is this
Yeah.
essentially option 2 then?
Oh gosh, Sarah, do you remember? We've been like back and forth
The
and
whole
around the
option
corner so
numbering
many
thing
times.
is not helping me because they're not numbered in this memo.
Yeah, I think
No.
the basic merger framework was revised option 2 because it was option 2 and then we split the first one into 2
Yeah.
different sections.
I would
so.
not make a motion based on any numbering because
Yeah, I
it's-
think just based on
Agreed.
this
got the
memo.
memory. Let's go from this memo, please.
Yeah, I would move the motion suggested by the executive director.
Second. So we're doing
Okay.
page.
And
Okay.
what we're asking staff to do is to put that stuff together as a potential tentative recommendation for us to consider at the next meeting?
That's what I'm hearing. Was that your motion, Commissioner
Yes.
Seeger?
So
Yes.
we're doing
We're not
basic-
moving anything out. We're directing you
Right.
to bring us a consolidated package for final review and discussion.
So for clarity, it's the basic merger framework with new subdivision X on page 18
Mhm.
and the purpose statement on page 19, right?
Yep.
Right?
Okay,
That's
Yes.
what I'm
all right.
understanding. Hopefully everybody else is on board with that.
Yes.
Okay, and we had a second?
Second.
Okay. All right, I will call the roll. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Hebner.
Aye.
Commissioner Jenkins is not here. Commissioner King,
Aye.
Commissioner Simpson.
Aye.
5.
Okay. Progress. Okay, I think that, is there anything else that we need to do?
No, just a reminder, our next meeting is October 30th. Yeah, so the requirement, the chair who will be outgoing at that point advised me that we need to require everybody to wear costumes, so.
Where my fencing?
Yeah, that's right.
I'll bring a saber.
If anybody has a conflict, please let me know, because we really need to make
Yeah.
sure we have a quorum moving forward if we want to get this one ready for introduction in next year.
Right.
2027. I
Yes.
can't believe I'm saying that
Yeah.
number.
And we still have a vacancy, right?
We still have a vacancy. I do check in with the appointment secretary. They have not filled it yet, which I think is not uncommon at this point.
Yep, in this point in the administration. Okay, well, thank you to everybody. Thank you to the presenters for being here, the presenters online. Appreciate your input as well. And
I just want to give one more shout out to my staff for working this weekend to make sure that all the public comments were up.
yes, much appreciated, team. Much appreciated. So with that, without objection, we are adjourned.